Must attend.
Simply new bunny. I told her, you were going college, no? I told I will open in mobile.
Diary ilva? Diary ilva? ಮಂತ್ರಿಯನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದಾರೆ ಅಂತ ಲಾಯರ್ ಇಟ್ಟಿದ್ರೆ ಇಲ್ವಾ ನೀವು? Let come tomorrow. What will happen in one day? Tomorrow. All right, 2:30. What do you want? For the examination, I'll relist it tomorrow. List it.
Matter ಆಮೇಲೆ ಒಂದು ರಿಪೋರ್ಟಿಂಗ್ ಅದು ಮಾತ್ರ ನಾಳೆಗೆ ಹಾಕಿ ಎರಡು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದೆ ಆಮೇಲೆ ಒಂದು ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಅದು ಮಾತ್ರ ನಾಳೆಗೆ ಹಾಕಿ
All the matters will be adjourned except the fresh matters and the matter for settlement.
Serial number 16, my lord. Third list, serial number 16. Stay request to be extended. Third list, my lord.
They're being adjourned.
Huh?
Adjourn ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಅದೇ ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು 16.
ಯಾವ್ದ್ರಲ್ಲಿ?
Third list 16 serial number.
Already. Check ಮಾಡಿ. What is the next step? Here to take notice for R1, Nagaya to take notice for R3. Sinchana to take notice for R2. She notice to R4. Office objections are overruled. Correct, but I can't do anything until you are found to be medically fit. What is it, madam? Number 1. List on date. ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? The benefit of an intermodal road. What was the fact of that case there? Against a disciplinary proceeding. Against a disciplinary proceeding.
Yes, sir. Termination and on the other hand, you are very one of them for within the age group in the community. Some kind of alone not get them paid. Not termination.
By virtue of this recruitment, they will lose their jobs. Make a statement that they will not lose their jobs.
Statement on that, that is irrelevant. But everything
I will simply say that you shall not terminate their services until further orders. You do whatever you want to do. If you want to recruit, it's up to you.
but also mentioned that the improvement is not.
I will not say anything. I will only say you will not. As good as granting an interim order and vacating the interim order at the same time. If I were to pass that order.
But sir, asking an order that they should not be sent out. That part of it remains, but it will not come in.
They can participate in that also.
Participate. And even if
ಇವಾಗ ನಿಮ್ಗೆ ಎಂಟ್ರಿ ಮಾಡು ನಿಮ್ ಕೆಲಸ ಉಳ್ಕೊಂಡ್ರೆ ಸಾಕಲ್ವ ಇವಾಗ whether you are entitled for regularization or not is a matter considered yet. How can I? ಇಲ್ಲಿದೆ. ಟ್ರೈಬ್ನಲ್ ಏನಿರೋದು ಅಲ್ಲಿ ಮ್ಯಾಟ್ರ್? ಇಲ್ಲ ಏನಿರೋದು ಮ್ಯಾಟ್ರ್? ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟ್ರ್ there? From 2006 it is pending this question of. No, they work for how many years?
Out of the creation, terminated or above. But at the same time, that is not.
Will you undertake that in case they succeed for regularization? No, in case they succeed for their claim, then what happens?
The condition that they should not be terminated, that will be complied.
No, but if you were to recruit somebody and then thereby scuttle the chance of regularization, then what should happen?
The better amount of regularization, better.
No, then your argument will be that there are no posts for regularization, then everything is filled up.
That cannot be a difference.
Make a statement that you.
That's why I said, now, promotions are giving in the product that they will not be terminated. They will not be terminated. At the same time, the recruitment proceedings, many of them will be.
No, that I know, but in case their claim for regulation is to succeed, you will not take up the plea that there are no posts for regularization. There are no vacancies available for them to be regularized. No, even then, if you make a statement that even in the event of the regularization, you will not take up the defense that there is no vacancy for regularization, then I'll grant that order. ಅದು ಎರಡು ಒಂದೇ ಆಗ್ಬಿಡುತ್ತಲ್ಲ ಪಾಟೀಲ್ರೆ. ನೀವು ಅದ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಇಟ್ಕೊಳ್ಳಿ. ಐ ಆಮ್ ಆರ್ಗಿಂಗ್ ಇನ್ ಯುವರ್ ಫೇವರ್. In the event they are regularized, in those proceedings you will not take up the plea that there are no vacancies available or regularizing them. You should not say there are no vacancies now, therefore I will not regularize. Make that statement.
There are no vacancies. There is an order of Ministerial Tribunal waiting for me.
You will not take up the defense, then I will consider that prayer. And this will virtually kill the entire process. You are going to throw them out by recruiting others and then say how many posts are available and how many persons are there. Vacancies ಎಷ್ಟು? ಯಾವ ಕ್ಯಾಟಗರಿ ನಿಮ್ದು? ನೀವೆಲ್ಲರೂ ಕೆಮಿಸ್ಟ್ ಕೊಡೋಣ. ನೀವು 300 ಜನ ಹೇಳಿದ್ರಲ್ಲ, ಇರೋದೇ ಇವಾಗ ರೆಕ್ರೂಟ್ಮೆಂಟ್ ಆಗ್ತಿರೋದೇ ಬರೀ 70 ಆದ್ರೆ That is why I don't want to go in the process of recruitment. But in the case of recruitment, you should not tomorrow deny their claim for regularization on the ground that there are no vacancies. Record your statement. Succeed Allah. If their claim for regularization is successful, either before the tribunal or before any other course, you will not take up the defense that there are no vacancies available. Lecture. I will simply say in the proceeding for regularization, they will not take up the plea. That the Nimgu recruitment agatala. Suppose you get recruitment under the notification. Which? You are responsible for that, isn't it? You are responsible for that. You chose this mode of contract employment, and you are now blaming them for the your.
I'm trying to say that we are being settled because some committee has come, they want to recruit. Some committee, instead of recruiting, have brought program their own persons illegally and trying
What was this rate division bench ruling?
license for the candidate, the employers and recruitment must say what is These are undertaking for the now. You will now undertaking for the bad for
the other alternative that I'm thinking is in this recruitment notification, you consider only their applications first, and thereafter. They have to be accommodated first, after having made them work for. Which?
Because of the matter. Take one thing to do. Wait for the extra one to be that several what
Where is the clause relating to these contractual employees? Where is the clause relating to their consideration of giving them weightage or whatever for the contractual employees? Where is the? So no preference is given to them.
Cannot be given under the law. You cannot make it under.
The claim of the petitioners is that they were working under various contractors and have been treated as contractual employees for more than how many years? 20 to 30 years. And their claim for regularization is pending before the tribunal. It is a case of the federation that there has been no recruitment conducted for the past 18 years, and therefore there is no justification for entertaining the claim of the petitioners challenge to the proposed recruitment notification. Next paragraph. It is to be noticed here that if the claim for regularization were to be ultimately in favor of the petitioners, the possibility of the recruitment being successful would not arise, since an argument would be advanced that there are no posts available for regularizing the petitioners. The fact also remains that this court, right from the year 2017, has protected the interest of the petitioners by granting an interim order of staying the recruitment notifications which had been issued earlier. In fact, in WP 52791/2017, a memo was filed by the respondents to the effect that they do not propose to recruit anyone under the notifications impugned therein. On the basis of the said memo, the writ petition was withdrawn. Next paragraph. Now, a fresh recruitment notification has been issued proposing to recruit recruit. How many posts you said? Recruit about that person. So, Learned counsel for the petitioner places strong reliance on the observations of the division bench rendered in writ appeal number page number ಯಾವುದು? Appeal 419/2016, which was filed by the milk unions, challenging the dismissal of the writ petitions filed by them, in which they had assailed the order of reference to the tribunal. In this writ appeal, the division bench has stated as follows, para 8. In my view, having regard to the fact that the petitioners are admittedly working as contractual employees for more than 23 years, and a division bench of this court has already observed that the contract employment was a sham one and they were indeed the employees of the milk union, it would be appropriate to stay the operation and execution of annexures A and A1 until further orders. It is also made clear that the petitioners shall not be terminated from their services until further orders. You notice that AJ to take notice for R1 alva. Vaishalya. The Institute of both R2 and R3. The Vaishalya to take notice for R2 and R3. Earlier, first notice for the ex parte entry model. You're getting a pay, you have a job at least. Okay? Shanmugappa. What is your right to be in that post? Where is your posting order? When were you posted there? You are posted on promotion. Serial number? Really, Arjuna? 5. Take out notice on, you have taken notice, you said. Yarmale? AJ to take notice for R1. Sri Shanmugappa is there to take notice for R2 to R6. Relist on notice to R7 deferred for the present. Relist day after tomorrow.
I think often because someone is entitled for and the petitioner is the second wife. Moreover, as the rules, the second wife is not entitled, since we are not obtaining permission from.
Then why did you pay 25% family pension from that particular date for almost 10 years? Why did the other 50% be given to her? Was the family pension give? Madam, pension ibur ಕೊಟ್ಟಿರ್ತಾನೆ ನೀವು ಇನ್ನೊಬ್ಬರಿಗೆ ಮುಂಚೆ ಅಂದ್ರೆ ಕೊಟ್ಟೆ ಇಲ್ವಾ ದೊಡ್ಡಪ್ಪನ್ ಕೊಟ್ಟೆ ಇಲ್ವಾ if you don't recognize second marriage, how did you reduce this pension by 50%? ನೀವಲ್ವಲ್ಲ ಅವ್ರ ತಾನೇ ಕೊಟ್ಟಿರೋದು. How did you reduce it to 50%? ಏನಕ್ಕೆ ಅಂತ ಇಲ್ಲ you should recognize the second wife or not? How can you recognize the first wife and only pay 50%? Then the compromise would have been different.
Even 50% already they have given.
ದೊಡ್ಡಮ್ಮನ್ಗೆ now Uchamma is dead, so now you are prepared to give to a dead person. They won't be eligible. They'll all be majors by now. If you have accepted the two marriages by virtue of being a party to the compromise, you are also a party to the compromise, thane?
Yeah, the parties.
You are a party. You did not challenge it. Why was the 50% pension not paid to this lady pursuant to the compromise? On what basis did you retain that 50%? I'll agree that you paid Uchaman tane kottideva. Arda in Arda N, how did you withhold 50%? Under which order? I want to know under which order you withheld 50%. That amounts to you recognizing the compromise decree, notwithstanding the rule.
Under of the Uttama claiming the rest of the amount.
Whatever he claims is different. Why did you withhold 50%? Under which order? Yen confusion, madam. You recognize the marriage or you don't recognize the marriage. How can you withhold 50%? For how many years? For 10 years? ನಿಮ್ಗೆ ಯಾಕೆ ಬಿಡಿ ಅವ್ರು ಜಗಳ ಆಡ್ತಾರೆ ಇವಾಗ ಅರ್ಧ ಏನಾಯ್ತು ಪೆನ್ಷನ್. I want to find out from you as to why you withheld 50%, on what basis? Ask them to fill an affidavit at 2:30. I will take action against them for playing around with their lives. You should have straight away said, no, I will not recognize the compromise. This is our rule. By giving only 50%, you deprive that lady of the full pension for her entire lifetime. Alva, the compromise would have been different. ಹೆಂಗ್ ಮೇಡಮ್ ಹಂಗಾರೆ ಕೊಟ್ಬಿಡಿ ಇವಾಗ ಪ್ರೆಸ್ಯೂಮ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಬಿಡಿ. ನಿಮ್ಮಷ್ಟು ನೀವೇ ಜಡ್ಜ್ ಕೂಡ ಆಗ್ಬಿಡ್ತೀರಾ, ಆಮೇಲೆ ಬೇಕಿದ್ದಾಗ ಕಾನೂನು ಮಾತಾಡ್ತೀರಾ. Ask them to fill an affidavit as to why that 50% was not more. I'll take action against them if they have done something on their own and now they want to say bring in the rule. We filed it. 2 weeks time is granted to file objections. In the meantime, the interim order granted release will continue. What is the main matter now? The recorded statement will be disposed of within a month or two and close the proceedings. If they don't dispose it of, then I'll give you liberty to revive this litigation. Or when will you finish? The petition is filed. Whether you agree or not, I will pass this order. Or else I'll dismiss it unnecessarily tomorrow. ನೀವು ಬಂದಿದ್ದೀರಾ ಅಂತ ನಾನು ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡ್ತಿದ್ದೀನಿ. ಸೀನಿಯರ್ ಬಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ. An order of suspension is impugned in this writ petition. It is not in dispute that pursuant to the order of suspension, articles of charge have already been issued against the petitioner. I'll give up all questions. I'll give up all, leave open all questions. Then the AG submits. I am prepared to give a finding that they have competence to suspend. Nim choice. Beku andre dismissal illa andre within 1.5 months I'll ask them to finish the inquiry. The same thing tane adu already I have already held in the other batch of cases that is the Supreme Court Srivatsa case. Once a benefit is granted to one employee, it will be applicable to all employees. The question of delay and acquiescence will arise only if you have rejected their claim and they have not taken any action against it. You cannot sit on their claim quietly and after you fail in the Supreme Court, get up and say, no, I will yet deny their claim on the ground that it is belated. In all those cases, also the same issue was involved. No question of considering. You will pay according to that judgment because this condition was considered by me. Rightly or wrongly, you know what to do next. The light of the judgment rendered the connected batch of writ petition. So on. This writ petition is allowed in the same terms, and the respondents are directed to grant the petitioner an annual increment and consequently prefix his salary and pension and pay the same to the petitioner within a period of 2 months from the date of receipt of a copy of this. In memo for dismissal, what is the order that is challenged here? Its HRH is under challenge. What is an HRH? Nimgen organ, what is the grievance? Why do ಇವಾಗ ಯಾಕೆ ಮೆಮೊ ಹಾಕಿದ್ರ? No, what is that got to do with our challenge to the change of cadre? No, the second prayer is not dependent on the first prayer. They are independent, isn't it?
So my lord, the petition has been passed. To say that the promotion has been given.
Dismiss ಮಾಡಕ್ಕಾಗಲ್ಲ. I hear them. List. Opponent? Easy to take notice for R9. Was scheduled to be amended. Forthwith. Interim to continue till next day. ಹಂಗಾರೆ ಮುಗಿಸ್ಕೊಡಿ ಇದನ್ನ. ನಿಮ್ಗಿಂತ ಜಾಸ್ತಿ ನನಗೆ ಆಂಗ್ಸೈಟಿ ಇದೆ ಮುಗಿಸೋದಕ್ಕೆ. The objections are overruled for the present. Ready, list. Then a lunch attender. What is A1/23? Copy sir ಮಾಡಿದರಾ? Received the copy. Counsel the petitioner admits that copy of the application has been served on it. What is the statement of objections? ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಟ್ಟಿದ್ದಾರೆ. And he also submits that he has received the statement of objections filed by R2. Who's R4, R8 and R9? The counsel for the second respondent, the KM Ramesha, is directed to instruct his client to serve copies of the writ petition on R4, R8 and R9. So counsel for the petitioner is directed to furnish copies of the writ petition and annexures on the learned counsel appearing for second respondent. Yaar neema ke getting stay. What is the interim order granted? Orla, have you filled up all the posts? ನೀವು ಹಾಕಿರೋದು ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದಾರ ಸೊಸೈಟಿ ಮಾಡಿದಾರ ಎಲ್ಲಿದೆ ಅದರ C&R rules? That is the only point. Where is the C&R rules? Let me see the C&R rules first. ಎಲ್ಲಿದೆ? Page number 2. ಯಾರು ನಿಮ್ದ? The first diploma in drawing and painting. What is your diploma?
Diploma is diploma in painting. Diploma in painting is similar, right? Speak of the recognition of research qualification. Also, 5 years of diploma in for emergency.
No, the Chenda rule talks about pass diploma in drawing and painting examination or art master examination or diploma in painting or diploma in commercial or applied arts conducted by board or technical examinations. Who conducted the examinations insofar as that diploma is concerned? Then it's a recognized university, alva?
And also painting.
Then our then. Where's your degree? $49. Where's your degree? Who conducted this examination? Like then they specify board of technical examinations ಅಂತ ಹೇಳ್ತಾರೆ. In this they say board of technical ಅಂತಾನೆ ಹೇಳ್ತಾರಲ್ಲ. Conducted by the board of a board or are. We have a copy of that CNR rules. I don't think it's typed correctly. Are they saying that it is a diploma in painting which is
Yes.
you have a copy of this government notification 21/3/2006? Release call. Give it to him. Let us see. Release call. ಇಬ್ರು ಹಂಗಾರೆ
ಭಜಂತ್ರಿ ಅಸೋಸಿಯೇಟ್ಸ್.
ಪೆನ್ಷನ್ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಕೊಡ್ತಿದ್ರ ಹಂಗಾರೆ? ಪೆನ್ಷನ್ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಕೊಡ್ತಾ ಇದ್ರ?
ನಮ್ ಲಾಯರ್.
You will not get anything. Isn't it? How can they give you the dental benefits until you establish? ಇಬ್ರಿಗೂ ಇಲ್ಲ, ಇಬ್ರು
ನಮ್ದು ಇಲ್ಲ ಇಲ್ಲ.
ಈ ಕೋರ್ಟ್ ಬಂದಿರ ತಿರ್ಗಾ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ತೀರಾ, ಇನ್ನೊಂದು 2033 ವರೆಗೂ ನಡೆಸ್ತೀರಾ. 25 ಲಕ್ಷ. ಕೋರ್ಟ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಷ್ಟೇ ಜಗಾಡ್ಕೊಂಡು ಇಬ್ರಿಗೂ ಏನು ಸಿಗಲ್ಲ. ಅವ್ರಿಗೂ ಏಜ್ ಬರಾಗುತ್ತೆ, ನಿಮ್ಗೂ ಏನು ಸಿಗಲ್ಲ. ಇಲ್ಲ ಅವ್ರಿಗೆ you want a settlement so that both of you can live. You are not even recognized as a wife by them, so you are still in a worse position. They already they don't recognize you. ನೀವಿಷ್ಟು ಬಿಟ್ರೆ ನೀವಿಷ್ಟು ಪ್ರೀತಿ ವಿಶ್ವಾಸ ಇಟ್ಕೊಂಡಾಗ ಇವೆಲ್ಲ ಹಾಗೆ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಆಗೋದು. What do you want to do? You want to go to civil court? I'll permit you to go to civil court. ಅವ್ರ ಒಪ್ಪಲ್ಲ ಅಂತಲ್ಲ, ಅದ್ ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಏನಾರು ಹೇಳ್ಬೇಕು, ಅದನ್ನ ಹೇಳ್ತಿದ್ರೆ I think much will happen. Go to civil court. What else can I do? Today I gave you a lot of chance. ನಾನು ನಿಮ್ಮನ್ನ ಬೈತಿಲ್ಲ, ಪಾರ್ಟಿ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
ನೋಡಿ ಸೌಂಡೇ ಬರ್ತಾ ಇಲ್ಲ.
He is prepared to give up such a small amount and you are not agreeable to take that small amount and give him a job.
It's not independent, not a
This is a dispute which has arisen as a consequence of the death of G. Linganath, an employee of Bescom. The petitioner claims that he is the son of the deceased Linganath, while respond number 4 and 5 claim to be the wife and daughter of Linganath. The obvious fight is over the terminal benefits and the consequential compassion appointment that the dependents of a deceased employee are entitled to. President Counsel Shri B. L. Sanjeev, on verification of the records, submits that there is no entry made by the deceased employee regarding his marriage with the fourth respondent. It is submitted that as a matter of fact, no nomination has been made by the deceased employee. Next. The respondents have issued an endorsement calling upon the petitioner and the respondents to approach the appropriate court and obtain a decree regarding their entitlement, and their cases should be considered thereafter. In my view, this endorsement issued by Bescom cannot be found fault with, since admittedly the deceased employee has not nominated the fourth respondent as a second wife, and therefore our entitlement would only be after a right as a wife of the deceased is established. As a consequence, writ petition is dismissed. Liberty is reserved to the petitioner and the respondents 4 and 5 to approach a civil court and institute appropriate proceedings for establishing their legal rights to claim the terminal benefits arising out of the death of G. Linganath. For the writ petition. Starting with the writ petition. ಏನೇನೋ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಮುಗಿಸ್ತಿದ್ದೆ ನೀವು ಸುಮ್ಮನೆ. ಭಟ್ರೆ ನಿಮ್ಮ objections ಅಲ್ಲ. Page number? Yes. ಆ ಕೇಸಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರು? ಅಲ್ಲ, ಆ ಕೇಸಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸ್ ರಣಬೀರ್ When was this order passed? Next hearing. ಯಾವಾಗ ಮಾಡಿದ್ದು ಅದು? Well of what? Two 2002. No, are these two different? The annexure A and annexure E are different? When was that made? ನಿಮಿಷ. What is the amount that you are prepared to offer? No, in the Supreme Court decision, what is the amount determined? ಎಷ್ಟು ವರ್ಷ ಇದೆ ಸರ್ವಿಸ್? ಎಷ್ಟು ವರ್ಷ ಇದೆ ಸರ್ವಿಸ್ ನಿಮ್ಗೆ? ಈಗ ಎಷ್ಟು ಬರ್ತದೆ ಸಂಬಳ? ಇವಾಗ್ಲೂ ಬಟ್ 71 ದಿವಸದಿಂದ ಅಷ್ಟೇ ಕೊಟ್ಕೊಂಡ್ ಬಂದಿದ್ರ. Get the judgment. If the amount is somewhat reasonable, I'll consider, or else I will direct you to consider and continue her till she attains age of 60 years. If that amount is reasonable, if there's substantial sum. Get us the judgment, let us see. Yep. His objection is kept open. What is the main matter about? Noted. They will to take notice for first respondent. Who appears for Bemal? This one takes notice for R1. Yaru? Earlier on, layer appear agidru. NS Narasimha Swamy, direct take notice for respondents 2 to 5. He seeks for 2 days time to file his objections. And in this was the matter from the presence of R2 is dispensed with. Relist on the afternoon. Back it up. Happened. The previous matter. The respondents here. What's authority? What is the next therapy? There is no post for fitness in other. ಇಲ್ಲಿದೆ. Seven. Next year Bean. Altogether 50 ಜನಕ್ಕೆ ಕೇಳಿದ್ರು ಅವರು. ಇನ್ನೊಂದ್ ಜನ 11 ಜನ ತೆಗೆದಾಗ 73 50 ಆಗಲ್ವಲ್ಲ, 50 ಆಗಲ್ವಲ್ಲ, ಬರೀ 50. ಇಲ್ಲಿ next ಸರಿ they restricted only to 50 people. 50 ಅಂದ್ರೆ ಫಸ್ಟ್ ಇಬ್ಬರು ಮಾತ್ರ ಆಗ್ತಾರೆ ಅಷ್ಟೇ. What is your legal rate? Tell me. I don't know.
The thing is to bring an abstract law.
Where is the original order granting approval for 73 people?
Yes, now not actually big money.
Next year, yeah, na?
It's all out of appointment helpmate. Make sure the team will not be possible. We also find our builders will not be for fun. We just for it, item number three. ಅದೆಲ್ಲ ಕೊಡ್ತಾರೆ. ಕೇಳ್ಕೊಂಡು
What is the reason for you to reduce it to 50 from 100? La, annexure D ಅಲ್ಲಿ the approval was for 100 posts. Page number 40 ಗೆ ಬನ್ನಿ. Last paragraph ಮುಂದುವರೆದು. ಇಲ್ಲ ಸೆಕೆಂಡ್ paragraph ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರದ ಆದೇಶದ ಅನ್ವಯ. ಅಲ್ಲ ಮೇಲ್ಗಡೆ ಓದಿ ಫಸ್ಟ್ ಅದನ್ನೇ ಓದಿ ಮೇ ಬಿ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು. ರಾಜ್ಯದ ಕ್ರೀಡಾಪಟುಗಳ So 100 posts were approved, 80 and 20 technical. ಅದಾದ್ಮೇಲೆ ಸರ್ಕಾರದ ಅನುಮೋದನೆಯಂತೆ so these were the amount of people who were appointed because only that many amount of people came forward. So the approval is for 100 posts. Why did you reduce it to 50? No, 100. 100 ಅಲ್ಲಿ 73 ಅಷ್ಟೇ. ಅದನ್ನೇ ಕಮ್ಮಿ ಮಾಡಿದೆ ಅಂತ. It is already approved for 100. What is the reason for you to reduce it to 50? ಏನು ಕೌಂಟರ್ ಏನ್ ಹೇಳಿದ್ರ? ನೀವು ಕಳ್ಸಿದ 5 ಜನ ಸಾಕು ಅಂತನಾ? 100 ಇರೋದು ಅದ್ರಲ್ಲೂ 50ಕ್ಕೆ ಯಾಕೆ ಕಮ್ಮಿ ಮಾಡಿದ್ರಿ ಅಂತ. Why was it reduced to 50? ಇದ್ರಲ್ಲೂ 100 ಐತಿದ್ದು. This was the approval I said. Out of 100, only 73 came forward. 73 were filled up. Then you suddenly reduced to 50. What is the reason? Counsel for the learned AG to state as to why the approval for 100 posts was reduced to 50 under the government order dated 7/12/2020. Released on. Yeah, that's- Temperance. ಬೇರೆ ಯಾರು ರಿಟೈರ್ ಆಗಿಲ್ವಾ? ಒಬ್ಬರನ್ನ ರಿಟೈರ್
Is the first person to retire from this establishment, my lord, because
ಯಾರು ರಿಟೈರ್ ಆಗಿಲ್ವಾ?
first person to retire. I have also got the copies of the government orders, my lord. It only creates post.
ನಿಮಿಷ. ಇದು 23,684 ಎಲ್ಲಿದೆ? Government has accorded creation of the following step in GO dated 23/6/84. ಅಲ್ಲ, the government has accorded creation of the following step in the GO dated 23/6/84.
Nantra ide ಇಲ್ಲಿ actually copy ಇದೆ sir. I should have produced actually. ಅವರು ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ತಾವು ಹೇಳಿದ್ದೆ actually.
ಅದರ 84th ಕೊಡಿ 23/6/84 creation of post.
Then Nantra is num client today he has brought it, my lord, but I thought he will produce because it only creates my lord. It reads if you
On
are
what
asking-
conditions?
My lord, I will read the entire order, my lord. After detailed examination of the proposal of the government are pleased to accord sanction for creation of the following post to the Karnataka State Temperance Board for a period of 1 year. And able to secretary 11 posts have been created right from the post of secretary to the Temperance Board. Pay scale has been given, number of posts. In that, my lord, the post to which applicant was appointed is also there, my lord. And
No, is it
the
No,
order
ಬರೀ ಒಂದೊಂದು
ಇನ್ನೇನು
ವರ್ಷ-
ಹೇಳಿಲ್ಲ ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ ಬಗ್ಗೆ ಇನ್ನೇನು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ.
When? Because this is again for 1 year. 84 1 year. Then this 86 1 year. ಯಾವಾಗ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರಿ ಅಂತ I just want to see the
Confirmation order this away. Services of the petitioner has been confirmed.
no, the
That
post
order-
was created in 84.
Yes,
For each year it has been extended. When
Yes,
is the
pay scale-
confirmation of that post?
Confirmation, your lordship may kindly see, my lord. I have produced the pay confirmation of the post. The pay scale ಹಾಕಿದೀವಿ. Page number 31, my lord. As late as in 2003. Page number 31 annexure of ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಡೆ ಗಮನ ಸೆಳೆಯುತ್ತಾ ಸುದೀರ್ಘವಾದ ಇದೇ ಸಮಸಂಖ್ಯೆಯ ಸಂಸ್ಥೆ ಪುನರ್ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಮದ್ಯಪಾನ ನಿಯಮಗಳು ಮಂಡಳಿ ಕಾರ್ಯಕ್ರಮ ನಿರ್ವಹಣೆ ಸದ್ಯಕ್ಕೆ ಸದರಿ ನಿಯಮಗಳನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುವುದನ್ನು ತಿಳಿಸಿ ನಾನು ನಿರ್ದೇಶಿಸಲಾಗಿದ್ದೇನೆ ಅಷ್ಟೇ. ಅದನ್ನ ಏನ್
ಈಗ
annexure F, my lord, page number 31.
ಮಂಡಳಿಯ ರೂಪಿಸಿರುವ ಕರಡು ವ್ಯವಹಾರ ಹಾಗೂ ಆರ್ಥಿಕ ನಿರ್ಣಯ
ಇವರು ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ರು C&R ರೂಲ್ಸ್ ಎಲ್ಲ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ರೆ ಎವ್ರಿ ಟೈಮ್ ಇಟ್ ವಾಸ್ ಸೆಂಟ್ ಟು ಗವರ್ಮೆಂಟ್ ಇದನ್ನೇ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಈ ಪೋಸ್ಟ್ ಯಾವಾಗ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರು? See, initially 84, 85, 1 year. So then they can't claim that they are civil servants. When was it confirmed? And what are the terms of the confirmation of these amount of posts? ಯಾವುದು?
Page number 34 annexure H. ಒಂದ್ಸತಿ ಗವರ್ಮೆಂಟ್ ಕಳಿಸಿದಾಗ ಗವರ್ಮೆಂಟ್ ನವರು ಬೋರ್ಡ್ ಲೆವೆಲ್ ಅಲ್ಲೇ ಡಿಸಿಷನ್ ತಗೊಳ್ಳಿ ಅಂತ ಪೇಜ್ ನಂಬರ್ 34 annexure H ಮೇಲೆ. ನಿವೃತ್ತಿ ಸೌಲಭ್ಯಗಳಿಗೆ
Until then, CCR will apply. Then he'll be entitled for pension. Then. So, but what about this? ಮಂಡಳಿ ತನ್ನದೇ ಆದ C&R ನಿಯಮಾವಳಿ ರೂಪಿಸಿಕೊಳ್ಳುವವರೆಗೆ ಈ ನೌಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸೇವಾ ನಿಯಮಾವಳಿಗಳ ಅನುಬಂಧಗಳಿಗೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅದೇ ಕಂಡೀಷನ್ ಹೇಳಿ.
You'll have to treat them as a civil servant, isn't it? The minus ಮಾಡಿ. ನೀವು ಅದಕ್ಕೆ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಅದಕ್ಕೆ ಅರಿಯರ್ಸ್ಗೆ. The petitioner was initially appointed on a contractual basis and ultimately by an order dated 12/12/1991. The services of the petitioner was regularized. It will be beneficial to extract the entire order under which the petitioner was regularized. Annexure B. As could be seen from the said order of regularization, the board sought for regularization of the appointment that it had made, and the government accorded its approval to the said post. Clause 2 of the conditions imposed for regularizing the petitioner categorically stated that until the C&R rules were framed by the Karnataka State Temperance Board, the provisions of the Karnataka Civil Service rules would be applicable. So clause 1 indicated that the petitioner was on a period of probation for a period of 2 years. So a conjoint reading of these two conditions would therefore clearly lead to the inference that the petitioner was regularly appointed as a government servant, and the service conditions that are applicable to a government servant, that is, the Karnataka Civil Service rules, were made applicable to him until the Karnataka State Temperance Board framed its own regulations. It is not in dispute that till date, the Karnataka State Temperance Board is yet to frame its regulations. And as a consequence, the provisions of the KCSR would govern its employees. Next, the petitioner attained the age of superannuation on
Retirement. Now retire again. 2001. 2011.
the petitioner, ever since the order of regularization, has been working in the Temperance Board, and he was in fact granted a promotion as a superintendent, and he was also granted a revised pay as per
According to state pay scales, as and when state review.
as per the pay scales attached to a government servant. It is therefore clear that the board as well as the government treated the petitioner the same manner as a government servant and conferred on him all the benefits that were applicable to a government servant. The petitioner attained the age of superannuation on 2011, on 31/8/2011, and when he staked a claim for settlement of his terminal benefits, the board has taken the condition that there is no provision for it to pay pension and other benefits. It has accordingly issued an endorsement rejecting his claim. The petitioner had thereafter approached this court in WP 106/2014. And this court, while this court by an order dated 10th of January 2022, has observed that it's observed as follows, para 7. However, despite this order, the board has once again rejected the claim of the petitioner on the ground that the petitioner was the first employee to retire to attain the age of superannuation, and therefore his claim for being paid pension on par with other employees of the board would not apply. In short, it is the contention of the board that since there is no specific provision enabling it to pay pension, it cannot pay pension to the petitioner. The state government has also passed an order refusing the claim of the petitioner, and it has taken the stand that the board was to pass appropriate orders regarding the pension benefits. The board, it is stated, has passed a resolution approving a sum of rupees 3 lakhs to be paid to the petitioner towards his pensioner benefits. The petitioner, however, contends that since he was treated as a civil servant and the KCSR was made applicable to him throughout his tenure, he would have to necessarily be paid pension the same manner as that of a regular government servant.
One more request, my lord. I had relied on one decision of the division bench, my lord. One division where here that there was one institute called Adarsha Institute of Management, which was taking aid by the government. Avargu pension kodtirilla. One person by name M.R. Shankar approached the court. Page number 78, my lord. Writ petition. Page number 78. So writ petition was allowed, my lord. Against the division bench, writ appeal was filed and writ appeal also dismissed. Supreme Court also confirmed as per page. Therefore, what I am contending is that even though you don't have made arrangement for pension, following that judgment, you have to consider my case is another.
Petitioner also places reliance on a judgment rendered by a learned single judge of this court in relation to Adarsh Film Institute, which was an institution set up by the government on similar lines, and in that decision, the learned single judge of this court has upheld the claim of the petitioner therein for grant of pension, and division bench of this court in writ appeal number 134/2003 has also upheld the same. In my view, since the petitioner was confirmed as an employee of the Karnataka State Temperance Board with a specific
Lord,
condition.
33.
ನೀವೆಲ್ಲ ಹೇಳ್ಬಿಡಿ ಆಮೇಲೆ ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ ನಾನು ಡಿಕ್ಟೇಷನ್.
Not sorry, ma'am. Sorry, ma'am.
That until the board framed its own C&R rules, the provisions of the KCSR would be applicable to the petitioner. Since it is admitted that the board is yet to frame its own C&R rules, obviously, as per the terms of the regularization, the provisions of the KCSR would govern the service conditions of the petitioner. It cannot be in dispute that if the provisions of the KCSR govern the conditions of service of the petitioner, obviously, as a necessary consequence, you would also be entitled for grant of pension in the same manner as has been granted, as is eligible for a government servant. That view of the matter, and the view that the impugned orders cannot be sustained in the same or quashed, and the board as well as the government are directed to consider the petitioner for the purpose of payment of pension as if the petitioner was a government servant and pay the applicable pension and other benefits. It is in according to law. Directed both of
Limit, time limit of 3 months. Already 2011, 100 ವರ್ಷ ಆಗಿದೆ.
3 months.
Interest, my lord, interest because 11 years ಆಗಿದೆ.
Government will be entitled to deduct the sum of rupees 3 lakhs that has been paid by the board, that computing and paying the arrears of pension, the petitioner.
Interest ಇಲ್ವಾ ಬೇಡ ಸ್ವಾಮಿ interest. 11 years ಆಗಿದೆ ಅವಾಗಲೇ 11 years ಆಗಿದೆ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ 2011 retired for 12 years he has suffered without a pay.
No interest.
Right.
Realist. ಏನ್ ಸ್ಟೇ ಏನ್ ಬೇಕು ಅಷ್ಟು ಅರ್ಜೆಂಟ್? ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರ ಥರ್ಸ್ಡೇ ರೆಡಿ ಇದೀರಾ ಈಗ ಥರ್ಸ್ಡೇ That was not the order. So you can modify the order by your own. No, I said no the other day itself. You first deposit, or else I'll ask him to be present and initiate action for contempt because he's disobeyed the order. Kashtana, there is an order, you should comply with the order. First deposit, then make an application. You cannot for yourself assume that it makes no difference whether institution or not. I passed an order, you should have obeyed. And I refuse that request. ಇಲ್ಲ ನಾನಿಲ್ಲ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರು. You want me to keep him present? Also, so further learned counsel for the petitioner submits that the back wages to the extent 50% deposit madidre has been deposited, and he seeks for further time to deposit the balance 50% as ordered by this court on 19/9/2023. So, relist on so and so for further consideration. For further consideration. ಯಾವಾಗ ಏನಾದ್ರು ಮಾಡಿಫೈ ಮಾಡ್ತೀರಾ? On what ground is suspended? ಯಾವ ground ಮೇಲೆ?
My lord. And I have produced along with the memo the two rules, my lord. The lordship were
The government is saying that it proposes to amend the rules providing for an appellate authority.
along with the memo, my lord. Lord, the first one is the 2007 rules, my lord. Lord, the first one is the 2007 rules, my lord. That is the Karnataka Municipal Corporation Rules 1977.
Yes.
Lord, your lordship may kindly come to rule 2, my lord. Definition. Appointing authority means authority mentioned in the schedule.
Yes.
Lord, in the schedule, there is no authorities that has been mentioned.
Schedule ilvalla adralli.
Howdo. But subsequently, what has happened is one more rules were framed, my lord. That is, I have produced, my lord, at page 21 of the rules, my lord, of the memo. This is the Karnataka City Corporation Employees Conditions of Service Rules 1991. Lord, in this, my Lord, your last may kindly see, these rules were framed excising power conferred under section 421, read with subsection 4 of section 90 and 91 of the Karnataka Municipal Corporation Act 1976. Your Lordship yesterday referred to these 90 and 91 rules, my Lord, which provides for the government to frame the rules, my Lord, to prescribe the conditions of service for the employees of the BBMP. Based on that, my Lord, these rules were framed. Now, a schedule was enclosed to this, my Lord, that is at page 24, my Lord. Page 24. My Lord, Schedule 2, authorities competent to impose penalties under Rule 8 of the KCS classification CCA Rules 1957, and the authority to whom an appeal lies against the order of imposing penalties. Appointing authorities have been specified in Rule 2 of the KMC Rules 1977. Again, they refer to those rules, and Section 84 of the KMC Act 76. My Lord, here, my Lord, Group A officer appointing authority is government, and my Lord, Group B officers were commissioner. Subsequently, my Lord, this schedule was, my Lord, by a corrigendum, my Lord, amended at the very same page, my Lord, Schedule 2A.
2005 ಅಲ್ಲಿ.
Yes, my Lord. 2005 ಅಲ್ಲಿ, what they did is Group A officers only government is the competent. Then, my Lord, Group A lowest scale, that is Group A lowest scale, commissioner is the competent authority. My Lord, this notification was issued, amended pursuant to, my Lord, a corrigendum that was issued, which was also subject matter of litigation in writ petition 3427 of 2001, finalized in, my Lord, writ appeal 294 of 2002. I may be permitted to produce those two judgments, my Lord. My Lord, in the writ petition, my Lord, the petitioner had challenged the notice issued seeking to initiate departmental inquiry by the, my Lord, commissioner. My Lord, page 6, my Lord, para 9 of the writ petition order, my Lord.
Government ಅಂತ ಹೇಳಿದ್ರು.
Yes, my Lord. Because that was the government, my Lord, in the first schedule, my Lord, I read it was the government, and therefore commissioner has no power to initiate inquiry against me.
Government ತಾನೇ ಇವಾಗ ಅಥಾರಿಟಿ ನಿಮ್ಗೆ ಹಂಗಾರೆ?
No. Subsequently, my Lord, amendment was made to that Schedule 2 in 2005, prescribing commissioner as the competent authority.
What is your pay scale?
My pay scale is the same one, what is being prescribed, 10,620, 14,960.
Is that correct?
It is evident from the subsequent revised scale that was
But now these rules are no longer enforced by virtue of this notification, isn't it?
Yes, my Lord. Yes, my Lord. Now your lordship may kindly come to 2020 rules, which has been now framed.
What is your designation?
My Lord, Deputy Revenue Officer, my Lord. I am in the at serial number. Right,
Number?
Page 47, my Lord, of the IA produced.
No, the serial number ಹೇಳಿ ಸಾಕು.
Serial number 2, my Lord, that is Revenue Department, serial number 2. Yeah, ink page 40, my Lord. Your lordship are looking at 2020 rules, my Lord.
Yes, internal page ಹೇಳಿದೆ.
40, my Lord. Serial number 2, Deputy Revenue Officer, 52,650, 97,100. That is the, my Lord, basic scale for junior Group A officers. That is available in CCA Rules 1957, my Lord, Rule 5. Lordship may see Rule 5.
Correct, but under the Schedule 2, you are the appointing authority is the government, isn't it now?
No. The appointing authority is not government, my lord. My lord, your lordship may see section
No, come back.
82.
Come back to
Section,
this. Deputy revenue officer is a scale of 52,650.
yes, my lord.
97,100. Now
Yes.
come back to schedule 2.
Yes, my lord.
Schedule 2, page 43.
Yes, my lord.
Group A, post carrying pay scale above rupees so and so. Appointing authority is government, disciplinary authority is government.
Yes, my lord.
Then group A post with pay scale of rupees 74,400 to 10,000, 1 lakh 9,600. Again government.
Yes, that is wrong, my lord, because this group A scale with 74 to 4,000 is the commissioner who is the appointing authority in terms of section 84 of the KMC Act. That was
So long-
decided, my lord, that was decided in a judgment.
So
my lord.
long as this rule remains,
Yes, ma'am.
the 2020 rules remains,
Yes, ma'am.
whereby anybody who's in the pay scale of less than 74,400, the appointing authority is the government and the disciplinary authority is the government.
That is under challenge before this honorable court on the ground, my lord. It is contrary to the section 84 of the KMC Act.
Then we'll consider.
My lord, your lordship may kindly see the judgment relied on by me, my lord, identical matter, which annexure M, my lord, page 54. In the
What is a prayer in the writ petition?
My lord, I have sought for quashing of the schedule, clause 2 of the schedule 2 of the 2020 rules.
Amend madidra? Amend
Yes, my
madidra.
lord. Yes, my lord, I have amended.
Well, until the rule is struck down, it is presumed to be valid, isn't it?
Yes, my lord, but then the rule is contrary to 76 Act, my lord. That cannot be.
We'll consider that. Now, 2020 Act, how is it contradiction? The same argument, tana?
Yes, my lord. A rule cannot, my lord, override the Act, my lord.
ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಗೆ? 2 weeks time is granted to the state to file its counter.
My lord, state has filed the counter, my lord.
ಅದನ್ನ ಅಮೆಂಡ್ ಮಾಡ್ತಾರಂತೆ ಅವರು.
My lord, let there be an interim order of state till then, my lord.
Prima facie, if you want, I'll say that there's no ground for interim order in view of the fact that the rule is under challenge. And under the existing rule, it is the government which is the appointing authority. You want that order, I'll pass it now.
This honorable court has already granted an interim order under identical circumstances, my lord. My lord, in WP 11624 of 23.
Date of? $13,600 ಅಂತ ಹೇಳಿದ್ದೀನಿ. Review the DGA to take notice for R1 and Shri P. Anand to take notice for R2. It is pointed out by the learned counsel that there is an error which is apparent on the face of the record in para 2 of the order, as much as the date of death of the petitioner's father is stated as 13/6/2023, whereas it ought to have been 17/8/2011. Since this is an error apparent on the face of the record, para 2 of the order shall read as that his father had passed away on 17/8/2011. Review petitions according to this. It is also pointed out that the representation by the petitioner was seeking for appointment to a Group C post, and the same has not been mentioned in the order. In view of the fact that the petitioner had made a representation seeking for appointment on compassion grounds in Group C post, the order in paragraph 2 shall also read to be appropriate to direct respondent number 2 to consider the representation of the petitioner for appointing him to a Group C post. Because ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? So if you're not appointed, if you're not invited this faculty, they had to continue, isn't it?
They were there, even they were there also.
Is it a fact that these people were being invited even when you were working? No, is it on a factual basis? What he's saying is this invitation faculty was being invited even when you were. I'll come to that first on this factual basis. When you were working as guest faculty, was this system of having inviting faculty also available? Rather ಮುಂಚೆ.
They were there. We only. I was not a part. Sufficient made there was. No possibility of a point temporarily. It can be sufficient. When are they? The other part of this. Submission is recorded at least. Maybe in quick succession. Together it is. There is no possibility of appointing temporary.
As I said, there were 93 people, students studying already.
Yes, it is to remember we only this exercise has been done. This particular. Yes. Continue my having. Is that I not to appoint any temporary. The university is coming with a.
Have you discharged them?
The learning something better. It's on 11. Site will principal and 40. Principal and site. So this information is good. The appointment of these permanent lecturers as invited lecturers from supplement for the other form. Better order. I was not a petitioner, but.
Come to para 6 of your affidavit today. Yes. Please read. You are giving me an impression that you will go by this 16/2023 order, whereby you had invited 12 people to be invitational faculty. Whereas on 11/8/2023, you had already relieved them. In this para 6, you state that the existing students will be taken care of by the invitation faculty who had been appointed on 1/6/2023. 2 months afterwards, you have discharged them. So aren't you lying to me?
2 months later, telling a lie reporting. But the all these disciplinary just when the best point of the third one, just when the when you look at the fairness.
Let me listen to them.
Engage in all talk about nothing published.
Are you not misleading me by saying you had made submissions on the last date that the existing student of 93 would be taken care of by the existing faculty and by the invitation faculty? I was therefore reluctant to consider their case for interim order because there's already an existing strength to take care of the 93. Why did you not tell me about this relieving?
Just now only I get to know about the leave.
He knew. He was a person who signed the order.
Every year.
You said categorically, and he argued more than you argued, saying that invitation faculty would take care of these students. Is he not misleading me by relieving them on August 2023 and then stating on oath that it will be met by the invitation faculty? In the affidavit, he has reiterated that the workload will be met by the invited faculty. When the invited faculty
University last year review
ಈಗಾಗಲೇ ರಿಲೀವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಲ್ಲ ಆಗಸ್ಟ್ ಅಲ್ಲೇ.
ಇವಾಗ ಇಲ್ಲ ಕೆಲಸ ಸುಲಭ ತೊಗೊಳ್ತಾ ಇದೆ ಇವಾಗ ಮಾಡ್ತಾರೆ.
ಏನ್ ಮಾಡ್ತಾರಂತೆ? Then you appoint them, you appoint these people instead of those people. ಇವಾಗ ರಿಲೀವ್ ಮಾಡಿದಾರೆ ತಾನೆ ಅವ್ರನ್ನ, ಅವ್ರ ಯಾರು ಇಲ್ಲ ತಾನೆ, ಇವಾಗ ಅವ್ರಿಗೇನು ಅಫೆಕ್ಟ್ ಆಗಲ್ಲ ತಾನೆ, ಇವ್ರನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Right, or else I will pass strictures against him and initiate contempt proceedings for misleading me. He cannot take me for granted. He may take you for granted. I was so reluctant to even consider this case for interim prayer. I kept adjourning the matter only because I wanted to be sure of the facts. I didn't want to put the university in trouble nor give them undue benefit. And this is the way I am being treated. Had he not brought this to my notice, he would have continued on the basis that there's invitation faculty available to take care of the students. Our jawabdari irli velake, and he's a principal. Your choice, strictures, initiation of contempt, or you appoint these people and continue them. Until regular recruitment is done. Until regular recruitment is done, which I propose to do after a year, Vikram, you will continue them. You will not resort to this.
Continue them as property. Not as assistant professor.
Whatever post they were holding under the earlier notification, will continue till regular recruitments are made.
Period was over.
By virtue of a judicial order, it will continue till regular recruitment is made. Your choice, Rajan Kumar. It's your choice. I propose to take strong action against this gentleman who wanted to argue more than you and who was trying to mislead me. It's your choice. Illa, there must be a limit to this conduct. I'm not in. You argument madangare madi. I've told you the result beforehand. I heard you enough, and I heard him more than you. And if this is the way he behaves in the court, he has it coming for him. Yes, sir.
Just when the case is heard, the document is constant. For that, we have I make strong exception. This is not the first time. Every time I run into this is not fairness. Not fairness.
ಏನಾಯ್ತು ಮೇಡಮ್? ಏನಕ್ಕೆ ಅಡ್ಜರ್ನ್ ಅಂತ ಹೇಳಿದ? ಅವತ್ತೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಲ್ಲ. ಶಿವರಾಮ್, Sir,
Which are given to us by the government for regularization, page number 9. Page number 41.
you are challenging a notification.
Participating, we have also.
Yes. How do you say, madam, that this order is not applicable to them?
Maybe formulating the
No, why do you say that they were not eligible for absorption? Share or madly.
Nature is on page 20.
Next year,
Nature is page 26. Is the recommendation that
next year is some attendance expired.
Rectification ಅಲ್ಲಿ
Next year, F. ಇದು 25 to 2009 madam ಇದು. ಅಲ್ಲ ಪೂರ್ತಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ 25 to 2009.
As early as 2009, there one was candidate was completed for regularization. Up to interview, interview only answer. ಅದನ್ನೇ ಅಲ್ಲಿ ಇದನ್ನ ಬರ್ತಿದ್ದಾರೆ ಪೇಜ್ ನಂಬರ್ 23 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ತರ ಇದೆ ಒಂದ್ಸರಿ ಓದೋದು ನಂತರ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನ notification ಸಂಸ್ಥೆ ಗೌರವ ಧನ ಆಧಾರದ ಮೇಲೆ ಹತ್ತು ಅಭ್ಯರ್ಥಿಗಳ ಅರ್ಜಿಗಳಲ್ಲಿ ಸಂದರ್ಶನಕ್ಕೂ ಹಾಜರಾಗಿರುವುದು ಅವರುಗಳಲ್ಲಿ ಈ ಕೆಳಕಂಡ 3 ಆಯ್ಕೆಗಳಲ್ಲಿ ಹಾಗೆ ಉಳಿದಿದೆ. ಹೀಗಾಗಿ ನಿಮ್ಮ ವತಿಗಳ ಮೊದಲನೇ ಪಟ್ಟಿಯಲ್ಲಿ 3 ಜನ ಶಿಕ್ಷಕರು ಮಾತ್ರ ಕರ್ತವ್ಯಕ್ಕೆ ವರ್ಗ ಮಾಡಿಕೊಳ್ಳಿ. ನಂತರ ನೀಡಿದ 2ನೇ ಪಟ್ಟಿಯಲ್ಲಿ 22 ಮಂದಿ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಂಡು ಒಟ್ಟು 92 ಮಂದಿ ಶಿಕ್ಷಕರು ಮಾತ್ರ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಹೊರಡಿಸಿದ್ದಕ್ಕೆ 8 ಮಂದಿ ಭರ್ತಿಯಾಗದೆ ಉಳಿದಿದೆ. ಹಾಗಾಗಿ ಉಳಿದಿರುವ 8 ಹುದ್ದೆಗಳಲ್ಲಿ ಸಂದರ್ಶನಕ್ಕೆ ಹಾಜರಾಗಿದ್ದು ಆಯ್ಕೆಗೊಳ್ಳದೆ ಇನ್ನೂ ಗೌರವಧನ ಆದಾಯದ ಮೇಲೆ ಈ ಕೆಳಕಂಡ 3 ಮಂದಿ ಶಿಕ್ಷಕರಿಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ಹಾಗೂ ಮಾನವೀಯತೆ ಕೊಡಲಾಗಿದೆ. ಆಮೇಲೆ ಇವ್ರು 3 ಜನನ ಹಾಕಿ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ನೋಟಿಫಿಕೇಶನ್
ಏನಾಯ್ತು ಇದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಅವರು 3 ಜನರನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು.
ಇಲ್ಲ, you made a recommendation to treat them sympathetically when you are. ಆಯ್ತು ಮಾಡು. ಎಲ್ಲಿದೆ? Where is the refusal by the government? ಆಯ್ತು, next.
Page 35.
Yes,
2013 ಅಲ್ಲಿ ಆಗಿರೋ ಆರ್ಡರ್
yes.
ಅದು ಸೆಕೆಂಡ್ ಟೈಮ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮಗೆ ಅದರ ಪ್ರಕಾರವಾಗಿ ನೆಕ್ಸ್ಟ್ ರೌಂಡ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬೇಸಿಸ್ ಆಫ್ ಎಲಿಜಿಬಿಲಿಟಿ ಮಾಡಿ. So the notification was called for the petitioner applied for the notification by the annexure yes only ಅಲ್ಲಿ ಅವರು select.
Right, annexure.
Notification issued by the KE. Page 42.
Please read annexure G for me, H for me.
ಪ್ರಸ್ತಾವನೆ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಆಧಾರದ ಮೇಲೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ತೀವ್ರತ ಕಾಯಂಗೊಳಿಸುವ ಪ್ರಸ್ತಾವನೆಯು ಈ ಬಗ್ಗೆ ರಾಜ್ಯ ಸಂಪುಟದ ಸಂಖ್ಯೆ 8 ಹಾಗೂ ಪ್ರಕರಣ ಸಂಖ್ಯೆ 8 ತನ್ವಯ ಚರ್ಚಿಸಿ ಕೆಳಕಂಡಂತೆ ನಿರ್ಣಯಿಸಿದೆ. ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಸರ್ಕಾರಿ ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ವೃತ್ತಿಯ ಆಧಾರದ ಮೇಲೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಮೂಹ ಸಿ ಗಂಧದ ಬೋಧಕೇತರ ನೌಕರರ ಸೇವೆಯಲ್ಲಿ 1 ಬಾರಿಯ ಕ್ರಮವಾಗಿ ಕಾಯಂಗೊಳಿಸಲು ಉದ್ದೇಶಿಸಿರುವ ನೌಕರರು ಸಂಬಂಧಿಸಿದ ಹುದ್ದೆಗೆ ಅನುಗುಣವಾಗಿ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರಬೇಕು. ವೃತ್ತಿಯ ಆಧಾರದ ಮೇಲೆ ಕನಿಷ್ಠ 1 ವರ್ಷದ ಸೇವೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡಗಳಿಗೆ ಮೀಸಲಾಗಿರುವ ನಿಯಮಾನುಸಾರ ತುಂಬದೇ ಅವುಗಳನ್ನು ತಕ್ಷಣ ತುಂಬಲು ಕ್ರಮ ಜರುಗಿಸುತ್ತದೆ. ರಾಜ್ಯ ಸಂಪುಟದ ಮೇಲ್ಕಂಡ ನಿರ್ಣಯ.
So they had to fulfill 3 conditions. By this order, they were to be observed as a one-time measure. Correct? First is, as a one-time measure, all of them are absorbed. Second condition is, ಕಾಯಂಗೊಳಿಸಲು ಉದ್ದೇಶಿರುವ ನೌಕರರು ಸಂಬಂಧಿಸಿದ ಹುದ್ದೆಗೆ ಅನುಗುಣವಾಗಿ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರಬೇಕು. They had to be educationally qualified. Are they educationally qualified? Yes or no? That is all. It's not a complicated question. Where are they educationally qualified? If they are educationally qualified, and the other condition, ಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇರೆಗೆ ಕನಿಷ್ಠ 1 ವರ್ಷದ ಸೇವೆ. If they fulfill both the conditions, they automatically stand regularized. No question of appearing for an interview, no question of considering their cases.
ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಇದನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು ನಾನು ಫಸ್ಟ್ ಇಂದ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
This is meant to regularize those people working in your institute. In your institute, they were working on contract basis.
ನಮ್ಮ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಸ್ಟಾರ್ಟ್ ಆಗೋದಕ್ಕಿಂತ ಮುಂಚೆ ಅವರು ಮಾಡಿದ್ರು.
ಎಲ್ಲಾದ್ರೂ ಆಗಿರ್ಲಿ, ನಿಮ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಓಪನ್ ಮಾಡಿದಾಗ they were working in your institute on contractual basis. Yes or no?
ಅವರು ಸ್ವಾಮಿ ಗೌರ್ಮೆಂಟ್ ಯೂಸ್ ಮಾಡಿದ್ರು. They were appointed on a honorary basis by the district secretary under against the post by the Telecast authority.
Correct. Now that post was transferred to you.
ಇಲ್ಲ, ಆ ಪೋಸ್ಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಲಿಲ್ಲ. ಅದಾಗಿ ಅದಕ್ಕಾಗಿ ಹೆಲ್ತ್ ಅಂಡ್ ಫ್ಯಾಮಿಲಿ ವೆಲ್ಫೇರ್ ಇಂದ ನಮ್ಮ ಇದಕ್ಕೆ ಬಂದಿದ್ದಾರೆ. ಆ ಪೋಸ್ಟ್ ಈಗ ಆಲ್ರೆಡಿ
ಆಯ್ತು. At least you admit that they're working in your institution for how many years? They are working. So they have fulfilled that 1 year contractual requirement. Education qualification. So if they have complied with 2, regularize them. This is a government order. It makes no difference whether it's by the family welfare department or whatever. Regularize them.
Pressure representation. Administrative problem ಆಗ್ತಾ ಇರೋದು.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಹೇಳಿ, ಜುಡಿಷಿಯಲ್ ರಿಸಾಲ್ವ್ ಮಾಡೋಣ ಅದನ್ನ. ವಾಟ್ ಇಸ್ ಯುವರ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಪ್ರಾಬ್ಲಮ್?
ಅವರು ಫಸ್ಟ್ ನಮಗೆ ಮೇಲ್ ಬರೋದು ಅವರು ಹೆಲ್ತ್
ಅಲ್ಲ, ತಾವ್ ರೆಗ್ಯುಲೈಸ್ ಮಾಡ್ಬೇಕಾ ಅವ್ರು ರೆಗ್ಯುಲೈಸ್ ಮಾಡ್ಬೇಕಾ? ನೀವೇ ತಾನೇ ಮಾಡ್ಬೇಕು.
ನೀವ್ ಹೇಳೋದು ಹೆಲ್ತ್ ಫ್ಯಾಮಿಲಿ ನನ್ನ ಕಮಿಷನ್ ಅನ್ನ ನಾವು ಮಾಡ್ತೀವಿ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಹೆಲ್ತ್ ಅಂಡ್ ಫ್ಯಾಮಿಲಿ ಹೆಲ್ತ್ ಅಂಡ್ ಫ್ಯಾಮಿಲಿ ನಾವು ಮಾಡ್ತೀವಿ. ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ಅಂದ್ರೆ ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ನಾವು ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವರಿಗೆ ನಮ್ಗೆ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡೋಕೆ ಅವಕಾಶ ಇಲ್ಲ.
You have to regularize. Clause 1. Please read Annex H. ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿನ ಸರ್ಕಾರಿ ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಗಳನ್ನು ಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಮೂಹ ಸಿ ವೃಂದದ ಬೋಧಕೇತರ ನೌಕರ ಸೇವೆಯನ್ನು ಒಂದು ಬಾರಿಯ ಕ್ರಮವಾಗಿ ಕಾಯಂಗೊಳಿಸಲು ಅನುಮೋದಿಸಿದೆ. You have to do it. The college was initially run by that, it was attached to. This hospital was attached to the district hospital, isn't it?
Hospital local committee
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ನೀವು ರೆಗ್ಯುಲೈಸ್ ಮಾಡಿದ್ರಾ? ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ನೀವು ರೆಗ್ಯುಲೈಸ್ ಮಾಡಿದ್ರಾ? ಬೇರೆಯವ್ರಿಗೆ
ನಾವು ಇದು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಗವರ್ಮೆಂಟ್ ಆದ್ರೆ ಇದು ಆರ್ಡರ್ ನಾವು ಮಾಡಿದ್ವಿ.
ಬನ್ನಿ ಮೇಡಮ್. The petitioners have filed this writ petition. Nobody is appointed under this annexure notification. Annexure J. Have you appointed anybody?
Yeah, appointment officer Swami. Petitioner also has applied for Swami.
The petitioner has challenged the recruitment notification dated 26/11/2015. He has also sought for a mandamus to consider. Petitioners have also sought for a mandamus to consider the case of regularization of their service as staff nurses in the second respondent institute and to pay them equal pay on par with other permanent employees in terms of the recommendation made by the medical superintendent / district surgeon, district hospital, MIMS, Mandya. Next part. It is not in dispute that the government did pass an order resolving to regularize all those employees who are working in the medical colleges set up by them as a one-time measure on 14/3/2023. The contents of the said order would be beneficial and at their ends reproduced. As could be seen from the above, the first condition imposed for regularization was that the petitioner, the employees who were to be regularized had to be working on contract basis. The second condition was that they possessed the requisite education qualifications to hold that post. And the third condition was that they should have worked at least for 1 year on contractual basis. It is therefore clear that those of the employees who were working on contractual basis and who possessed the necessary educational qualification were automatically to be absorbed if they had rendered 1 year service on contract basis. It is, however, the case of the institute that the petitioners here had been appointed by the Ministry of Health and Family Welfare and not by the Medical Education Department, and therefore their cases could not be brought within the purview of the government order dated 14/3/2013. It is, however, admitted by the counsel appearing with the second respondent that the petitioners have in fact been working on contractual basis ever since the institute was set up in the year 2006. Since the petitioners have been admittedly working on a contractual basis from the year 2006, the question as to whether they were appointed by the Ministry of Health and Family Welfare or the Department of Medical Education would be of no consequence. The gist of the order of absorption is essentially to regularize those employees who were rendering service in the institute on contractual basis and who possess the necessary educational qualifications. It would really make no difference as to whether they were appointed by the Ministry of Health and Family Welfare or by the Department of Medical Education, having regard to the fact that both of them are medical departments and both of them are working in order to ensure that the medical service rendered by the state is appropriately taken care of. In this view of the matter, the argument that because the petitioners were appointed by the Ministry of Health and Family Welfare, they cannot be regularized, cannot be accepted. Same is therefore rejected. As a consequence, since the petitioners have been working second respondent institute ever since its inception, and they possess the necessary educational qualifications, the second respondent is directed to regularize them in accordance with the government order dated 14/3/2013. That order shall be complied with within a period of 2 months from the date of receipt of a copy of this order. 3 months.
Lord, in serial number 32, my lords, I appear for the counsel for 9th respondent, my lord.
What is the matter about?
This matter is about selection of a physical education teacher in a government aided institution. First time when it was made, they found that the committee itself was not constituted in accordance with law, and therefore they cancelled it and made another selection. In the first selection, the candidate who got elected, the candidate who was not elected, 9th respondent, filed a revision petition. Revision petition came to be allowed, and direction was given to immediately cancel the appointment of the petitioner. Against that, the petitioner is approached, and there's an interim order of stay operating in his favor right from 2017, and he continues to be working as physical education teacher. Now, the order passed in the revision is challenged. Page. The revision order is at page.
You are the successful candidate.
No, I'm not a successful candidate, my lord. The
You are the
petitioner.
revision petitioner, isn't it? You are the revision petitioner there in the,
ಇಲ್ಲ, I'm not the writ petitioner here.
no, only revision petitioner.
ಹೌದೌದು, ನಾನು. In the revision petition, the school also came and said they are wrongly constituted the committee. Page 130.
What is your challenge to this appointment of the ninth respondent? What is the post for? Post of? When were you appointed? What is the date of the notification?
So that my case is concerned, that is considered for approval. That's not, it comes up with another place. Which has no much structure of the meeting.
When was the appointment made, selection made according to you?
Page 33, Miller's appointment. Page 33. Page 18/8/2015.
10/8/2015.
18/8/2015. Page 34 al ಕಾಣುತ್ತದು.
Yes, then what happened?
Reasons- The reasons for allowing the revision petition could be added page 138.
Problem is, does not get in our. But in spite of that, the authority takes.
This order is set aside on 30/12/2016.
Yes, Philip. ಹೌದು.
And fresh recruitment to be made.
30/12/2016.
Okay, read page 140.
Yes, Philip, 140.
What are the orders that is passed? Annexure.
ಶಿಕ್ಷಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಅವರು ದಿನಾಂಕ 10/8 ಅಂಕೆ 2000 ನೇಮಕಾತಿಯನ್ನು ನಿಮಗೆ ಹೊರಡಿಸುವ ಆದೇಶವನ್ನು ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. So it was cancelled. Direction of direction for fresh appointment.
So re-notify for this appointment. On what ground did this revision authority come to the conclusion that your appointment was bad? What are the grounds? You just tell me, then you come and argue. Yes. Please read that paragraph. Or 8, huh? Yes. So two grounds. Two grounds. Basically, 7 members were in the selection committee as against the 5 that were required. Then there was no subject expert as on this particular selection committee. These are the 2 grounds. And the management admitted, yes, there was a mistake committed by them. Therefore, we'll ignore their concession. But how many people were in the committee? Was it in accordance with the rules? Who are the 2 extra members? You tell me, you appeared for the interview. How many people were there? Who were the people who were a part of the selection committee? Was there a subject expert as contemplated under the rules? Who was the subject expert according to you? Been selected. The process of selection is correct, they enter the matter. If it is incorrect, only then interference. He is saying that there were 7 members in the committee as against the 5 contemplated under the rules. He also says there was no subject expert which is required under the rules. What is your answer to those 2 questions is all that will remain.
Your lordship gets at page 98, my lord, 7 members, where they have evaluated.
Where is the outside expert? Ashte alva, Shrikant, if there are 7 people, what can you do? And if there's no subject expert? Let us see the rules. Which is the rules? If he is a party to a wrongdoing, it will not save the wrongdoing. So let us see the rule. Rules. Let me look at the rules first. I will direct them to initiate action against that particular officer who did not inform them about the requirement of the rule, if that satisfies you. This is the power of revision. If the records indicate that there were 7 people, you dispute the fact that there are 7 people, then you are admitting that. So let us look at the rules, whether they are mandatory or directory, or they can disregard those rules. You are continuing in service now. Nimgen benefit agutte Murthy avare ivaga if I dismiss the
Is the actual second time when they conducted, my client got the first place, but they did not publish it.
no, but
And now if a fresh recruitment takes place,
Ramurthure, now the direction is to re-notify. If they re-notify, you will not get the job. You will be time barred.
Allah.
Age bar ಆಗುತ್ತಲ್ಲ.
Age ಇದೆಯಂತೆ. My instructions are he still has age.
He was 39 in 2017.
ನೋಡಿ.
He'll be 46 now.
17 and 6, so 45. Age is.
ಅವ್ರು ಏನೋ ಕೆಲಸ ಇದೆ ಬಿಡಿ ಸುಮ್ಮನೆ why should we go into all this now? ನಿಮ್ಗಂತೂ ಕೆಲಸ ಸಿಗಲ್ವಲ್ಲ. Since you have not challenged the order. You should have challenged the order saying that you should have been appointed in his place. You accepted the order of re-notifying the vacancy.
How, in fact, we did not challenge, my client did not challenge the second recruitment where he was placed first. In fact, that he should have challenged, but then.
Do you think it's worth going into and taking away his job when you can't get that job?
ಇದು ಏಜ್ ಎಷ್ಟು ಅಂತ ನನಗೂ ಅಷ್ಟು ಕರೆಕ್ಟ್.
ಫಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ 39 ವರ್ಷ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಏಜ್ ಇಸ್ ಕರೆಕ್ಟ್ ಬಟ್ ಬಾರ್ಡ್ ಯಾವಾಗ? I am sorry, my lord, I have not got myself brief with regard to age. Time bar for becoming ineligible because of age. Eligibility.
ಏಜ್ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ ಎಲ್ಲಿ ಇದರಲ್ಲೂ ಇಲ್ಲ ಯಾವುದರಲ್ಲಿ. Even in the Karnataka education institutions recruitment and terms and conditions service ಆ ರೂಲ್ಸ್ ಅಲ್ಲೂ ಏಜ್ ಹಾಕಿಲ್ಲ.
ರೂಲ್ 4 ನೋಡಿ.
ರೂಲ್ 4 ಅಲ್ಲಿ eligibility of candidates for the interview ಅಷ್ಟೇ ಹೇಳುತ್ತೆ. For the purpose of selection of candidates for the interview, selecting authority should prepare a list of names.
Rule 4 of this rules says no employee who is not within the age limit prescribed for recruitment the corresponding post in government educational institutions shall be eligible for appointment to any post in any institution. So you will now be 45 years, you will not be eligible. Do you think it's worthwhile?
Only if the notification is quashed, but then this fresh selection will not save my age factor. And Avaga notification issue and quash ಆಯ್ತು, therefore I am entitled to also take up the ಇದು ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ.
ನಿಮ್ ರೆಡ್ ಪೆಡಿಷನ್ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಬಿಡಿ, ಏನೋ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಿದಾರಲ್ಲ.
ಒಂದಿನ ಟೈಮ್ ಕೊಡಿ, ನಾಳೆ ಹಾಕೊಡಿ. ಅಲ್ಲ the instructing council instead of, because I am not too sure of what it is. ಅವ್ರು ಏನ್ ಮಾಡ್ತಿದಾರೆ ಕೇಳ್ಕೊತೀನಿ ಕರೆದು.
Today, even if the board was then again, this requirement is even more.
ಇಲ್ಲ ಸಭೆ ಹೇಗಾಗಿದೆ, my client may not be
ಮಾಡಿದ್ರಲ್ವಾ ಅಂತ ನಾನು.
Permanent looked at all the group, players, you know. They were, however, made permanent. In 2020, they are considered document by the the respondent was and they were coming the year to 9 because of this 2015, there were no separate figure and recruitment notes with that. Only they were merged with the Karnataka state legal services. In one they were brought in immediately because they proposed that probation. Now, my lords, what to be done? They were to be paid. That time they have merged from their meeting. Yet none of the respondents have into that facility. And what they are challenging is to be promoted to senior assistant. A stenographer must have been 6 years as a stenographer. In addition, he or she should have worked for 1 year as an what happened to stenographer? Taking the exam. An assistant to senior for administration. So, when you say 1 year, be done by the stenographer in order to be eligible to be promoted to senior. Because to senior assistant is not an assistant who can be here. As an assistant is also promoted. Stenographer is 6 years, stenographer plus 1 year assistant also promoted. What is the intent to know is that they need to have certain qualifications. Also, they do not, the stenographer does not get any administration. Happens. So they will make permanent in 2017, but period was released. They do not file their objections to this. That was released in 2017. 2018, the respondents were promoted from stenographer to only then they file these. Now, by virtue of these respondents having put in as senior, they are eligible to be promoted to H0. Now, what the petitions are saying that they are eligible directly to go to H0. This rule is not there and they are trying to use 2015. It is there right from 1981. Everybody who wanted to seek for promotion would seek authority. They would make an application, work for 1 year as not today. They did not say they did not know what to do. Even the petitioner who are transferred have made application to work as assistants now. They have made applications that they want to work.
They are challenging annexure D.
Is the notification.
You are appointed in running local law. There was no also allowed.
They are.
Where is your appointment order? Stenographers, huh? But by the KSLS only.
Yes. I'm telling you.
We are not age. You could pass all the departmental examination during the period of probation. Age 20 not last one there.
So when they are appointed, the recruitment rules was not there.
Not there.
When was recruitment rules framed?
They were worked with the second one and the new the first.
Come back to annexure D. Where is that merger that you're talking about? When they were appointed to the permanent Lok Adalat, according to there were no C&R rules. And when were the respondents appointed? Same period.
They are all unions.
Petitioners and respondents. Juniors and thing heltira?
But senior petition.
Like in this office order that is produced annexed year. Annexed year. Annexed.
Yeah, it was the point the matter of it. Appointed for the year, appointed to the matter of it in the year.
When? You appear for? You? You should be able to tell me, madam, whether if their initial appointment is after them.
They were appointed to the government Contractual, which is not a part
They-
as temporary employee.
Temporary and then.
So that was the probation for 2 years.
We were in the
When were they?
And we can check it. Only with the funding in the basis, purely basis of temporary, they are to get at one fourth line. Actually, page 17. Dated 14 May of the line.
Page. Yes.
There are 50 fourth line.
Yes.
Purely temporary. The probation was declared successful only in 2016. But we are funding for the year 1.3%.
We were in the district.
The issue knew that they are
Yes, new address.
Number 5. And number 10, no, she's from area 44. One name is Marad, 5, 6, and 8. Number 10 is promoted.
First petition is a serial number.
Number 5, page 40.
Rupa ಅಂತ ಇದೆ ಇಲ್ಲಿ. Deepak.
First petitioner is Marad, Rupa, and she is clear number 8.
8.
Petition number 2. Marad, clear number
5.
5. Then Marad, you are Marad is speaker.
Where are the respondents?
Point number not she is not this is number 8. Point number 8. Her name is Contempt not 3 was appointed on 27/8/2009. Other respondents are all not and FDA.
ಎಲ್ಲರಿಗೂ ಡೈರೆಕ್ಟ್ ರೆಕ್ರೂಟ್ಮೆಂಟ್ ತೋರಿಸಿರಲ್ಲ ಮೇಡಮ್ ನೀವು. You can't call them temporary employees. They were appointed.
They were taken as their.
So admittedly, all the respondents are junior to them.
No,
In the date of entry.
Their challenge is of either the 2016 amendment. So my defense was, even if the 2016 amendment goes, even prior to it, when they were in appointed, even then this 1 year to be working as an assistant was. Now I have the experience before the year 1981, there was the legal services board also required promotion from stenographer to theater. 1 year as assistant work, they will work. So you will pay for 90.
So you will decide who will work as assistant, isn't it?
Agree that this is what is happening, you know. It was not.
Not all of them will get an opportunity to work as an assistant unless you give them that opportunity.
Enable an application, say, as soon as an application, we will put another assistant. This is happening. This is the thing when they were there, when they were appointed. So they cannot question what is already.
Show me the rule which says the moment they give an application that you will appoint them as assistant. You may have granted approval for everybody, but if you don't give them a chance to work as an assistant,
It's not their allegation also. They don't make an application for.
disregard that particular requirement and consider the case of promotion. That is all.
Yes, we can.
No, from the date on which the juniors have been appointed, from that particular date.
What happened? They have worked from demographic. They have been promoted to senior. Now 6 years they are putting as senior. Now they are entitled for.
Were they entitled to work as senior assistants when they were juniors to them?
They did not even make an application. I will place all the material on record. Can you grant me 2 weeks back? I place all the material on record. People who are inside also will be affected.
You are making.
This is not. This was the challenge now. 1981 rules are there. 2023.
Whatever happens from what can be done. If there's illegality, then illegality.
This was not a problem. But they are keeping it different. What the first time you go to this amendment is brought. I brought this to some of the board.
It's not very difficult for me to permit them to amend.
What is happening? On this.
List further consideration. ಬನ್ನಿ ನಾಳೆ ಕೋರೆಗೆ get them and come, get the other side and come. ನೀವು ಯಾರು 50? ಹಾ really the last chance. 2 weeks time is granted to file objections. Relist on. Yes. ಅವ್ರು ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ನೀವು. ಬಂದ್ರೆ ತಗೊಳ್ತೀನಿ. ಬಂದ್ರೆ ತಗೊಳ್ತೀನಿ. ಏನ್ ಮ್ಯಾಟ್ರ್ ಹೇಳಿ? ಅವತ್ತು ಥರ್ಸ್ಡೇ ಯಾರಂತ ಗೊತ್ತು? Who's opposing you? Get her if she comes at 4:30 and says it is covered, and take it up. ಅವ್ರು ಬರ್ಬೇಕು, ಇಲ್ಲರ ತಗೊಳಲ್ಲ. Get the other side. Oh, I can't take up. ಇವತ್ತು ಬೇಡ, 8 ತಗೋಗಿದೆ. Yes.
Not to further that plot, the matter particularly plot, recruitment of assistant professors. No project subject was being. There are looking to the earlier than why that, but stating that you could not use article will not make under the Supreme Court. But because you are take a
No,
if it is intervening product.
ಇಲ್ಲ ಅವ್ರೇನೋ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. What is your stand? No, what is your stand? If the government says reconsider, how can you say you will not reconsider? It's up to them. They are superior to you, isn't it? Isn't a direction by them binding on you? Then 230 crore. Yes. Date ಕೊಡ್ತಾರೆ. Date ಕೊಡ್ತಾರೆ. ಯಾರ್ದು ಗೊತ್ತಾಗ್ತದೆ ನಂಗೆ ಹೇಳ್ತಿರೋದು. ನಿಮ್ದೇನು? ಏನ ಬೇಕಿತ್ತು? ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Court officer? Sir, court officer? Court officer, sir. Court officer? Serial number 38. Sir. ಊಟ ತಂದ ತಂದ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಾತಾಡಲ್ಲ.
Next week ಬರುತ್ತೆ. 4:30 da. ನೀವು ಯಾರಿಗೆ ಪಿಟಿಷನ್ ಇಲ್ಲ?
End of the list. Fresh matter. Mood.
ಹಂಗೆ ಅವರು
Sorry.
ನಂಬರ್ 2 ಅಂತ ನಿಮ್ಗೆ.
Oh, I'm sorry.
What are you challenging? ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮಧ್ಯಂತರ ತೀರ್ಪಿನ ಮೇಲೆ You served a copy on Sunday? What happened? What happened? Notice I'll have it tomorrow. Last time ಯಾರು appear ಆದ್ರು ಆ ಕೇಸಲ್ಲಿ? Who appeared? This petition still pending? 43318?
That is still pending. What happened during the presidency of that? They passed yet another order in 2021. That connection is ready to. Saying that it is relevant for the.
Who's appearing there? They could notice, I'll hear them and then pass out. I'll have it tomorrow. AJ to take notice for R1. Ajendra Kumar need to take notice for R2 North. Release to me. Tomorrow.
Appearing for the petitioners.
Yes.
Appearing for the petitioners permission online. The petitioner is challenging the order of transfer. Am I audible, Lordship?
Yes, yes.
Annexure A, your Lordship, is issued by the Finance Department. The petitioner is working as a general manager, a cadre officer in the Rajiv Gandhi Housing Corporation. I request your Lordship kindly take for a moment the C&R rules. Only two modes are applicable for the appointment of general manager. That your Lordship get it in page 33, page 33, your Lordship. Serial number 5, Lordship got it?
Yes.
General manager, finance and accounts. One is through direct recruitment, another is through by promotion on seniority come merit from the candidate of AGM. The petitioner is a promotee to the post of general manager. There is only one post available in the department, Rajiv Gandhi Housing Corporation.
Already working as GM finance.
I am GM finance. Now, the finance department has transferred a person who is ineligible, is in the cadre of deputy director. General manager finance is a joint controller cadre. He has been posted by the finance department. Finance
Yes.
department has no authority. My posting is, your lordship get it, I was deputed earlier to KBGNL.
Where is
Later
your order of posting?
your lordship get it in Annexure D, page 39. 22/9/2023. Typed
You're on
copy.
deputation.
I am not deputation. I am a cadre officer. Earlier, I was on deputation to KBGNL. I reverted back to the department. ಅಧಿಕಾರಿಯಾಗಿ ನಿಯೋಜಿಸಲಾಗಿದ್ದ ಪ್ರಸ್ತುತ ಸರ್ಕಾರ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 5/2/2023 ಅನ್ವಯ ಬಿಡುಗಡೆಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಶ್ರೀ ಬಾಪುಗೌಡ ಎನ್ ಬಿರಾದರ್ ಪ್ರಧಾನ ವ್ಯವಸ್ಥಾಪಕರು ಇವರ ಮೂಲತಃ ರಾಜೀವ್ ಗಾಂಧಿ ವಸತಿ ನಿಗಮದ ಅಧಿಕಾರಿಯಾಗಿರೋದ್ರಿಂದ ರಾಜೀವ್ ಗಾಂಧಿ ವಸತಿ ನಿಗಮ ಪ್ರಧಾನ ವ್ಯವಸ್ಥಾಪಕರ ಹುದ್ದೆಗೆ ಮರು ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಲಾಗಿದೆ. ಐ ಬಿನ್ ರಿವರ್ಟೆಡ್ ಟು ಮೈ ಒರಿಜಿನಲ್ ಪೋಸ್ಟ್ ಇನ್ ವಿಚ್ ಐ ಆಮ್ ವರ್ಕಿಂಗ್.
ನೀವು ನಿಮ್ಮನೇಲಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
ನನ್ನನ್ನು ಇಲ್ಲಿಗೆ ಈಗ ಜನರಲ್ ಮ್ಯಾನೇಜರ್ ಫೈನಾನ್ಸ್ ಟು ಮೈ ಒರಿಜಿನಲ್ ಪೋಸ್ಟ್.
By virtue of this order, what has happened? By virtue of Annexure A?
Annexure A, my name is, I am working over there now. One Jairam is posted by the finance department. They have no authority.
Where are you posted?
ನನ್ನ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ ಎಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ನನ್ನ ನೇಮೇ ತೋರಿಸಿಲ್ಲ ಅಲ್ಲಿ. ಮೋರ್ ಓವರ್ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ನೋ ಅಥಾರಿಟಿ.
ಆಫೀಸರ್ ಮಾಡಿದಿರ ಅವ್ರಿಗೆ AGA?
ಸರ್ ಮಾಡಿದ್ದೀನಿ.
ನೋಡಿದಿರಾ?
Finance department has no authority. The housing department to replace that to a header officer.
ನೋಡಿದಿರಾ? ಆಫೀಸರ್ ಮಾಡಿದಿರಾ?
ಬೆಳಿಗ್ಗೆ ಸರ್ ಮಾಡಿಬಿಟ್ಟು ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ನೋಡಿ, ಟೇಕ್ ನೋಟಿಸ್. DG to take notice for respondents 1 to 4. Notice to R4 record for the present. ಯಾವತ್ತು ಬೇಕು ಮೇಡಮ್? Relist on swans. Until then, Annexure A, so far as it relates to the petitioner, so far as
Posting of fourth respondent, ನನ್ನ ನೇಮ್ ಇಲ್ಲ ಅಲ್ಲಿ. Posting of fourth respondent.
posting of the fifth respondent shall not be given effect.
Publish.
No, you said he will finish the proceedings within 1 month. ಇದು ಕೂಡ ಹೆಂಗೆ ಕೊಡಿ ಸಾಕು ನೋಡ್ತೀನಿ. After vacation, after vacation. Need to file the affidavit.
24/2012. The new act came to force on the Karnataka daily wages employees. What has was passed pursuant to the directions. Coming to comment by Nacho, Karnataka daily wages employees welfare act.
This court order or regularization or consent?
Last case of the, my notes, look at the. Page 24, last case, the regularization order was passed, but before the interest of. Last case and the regularization order, but before I told you as of market. Together in case matter, and 1 million. That is the order dated 16/7/2014. Consider in accordance with Constitution.
ಇವ್ರು ಯಾಕ್ ಮಾಡಲ್ಲ?
Sanction post area.
What way is their case different? ಅವ್ರಿಗೆ ಮಾಡಿದ್ಮೇಲೆ ಇವ್ರಿಗೆ ಮಾಡಲ್ವಾ?
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಫಂಡ್ ಗೌರ್ಮೆಂಟ್ ಇಂದ ಬರಬೇಕು. ಜನ ಇದ್ದಾರೆ ಜನಕ್ಕೆ ಆಲ್ರೆಡಿ ಬಾಕಿ ಗೌರ್ಮೆಂಟ್ ಫಂಡ್ ಕೊಡ್ಬೇಕು.
ಅವ್ರು ಫಂಡ್ ಕೊಡ್ತಾರೆ, ನೀವು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಬಿಟ್ರಿ. ಅವ್ರನ್ನ ರೆಗ್ಯುಲೈಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಮಾಡಿದ್ರೆ?
Convince by not score on this form. What you regularize the sanction not negative. But if you merely on the fact that if it was given to some other place, cannot be extended to in addition to this, you
have done whatever we have done, therefore don't do anything new. ಇದ್ರದ್ದು ಹೇಳಿ ಫಸ್ಟ್ 2014 ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ನೀವು?
financial extend ಮಾಡಿದ್ವಿ.
I mean, still don't understand. I have no answer, Andre. Then what should we do? So ignore it. Then withdraw that order. Then he will be satisfied. Then he has no grounds.
What are the? But apart from that, the benefit of financial benefit has to extra from the court side.
Yeah, what same terms? Whatever you have given them, you also give it to them. Or withdraw the order, then his entire argument falls to the ground. Tomorrow. And you granted them benefits under the 2012 Act also. Your choice. No. All of them will come now. ನೀವೇ ಬರ್ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ. They were happy with that. You gave them this chance. Tomorrow. Number? Again, what is your instructions? I'll pass an order. That is the orders commission. I'll pass an order. I will hold that he is guilty of contempt. He is present, alva. I will initiate proceedings against him. ಆತರ ಬರ್ದಿಲ್ಲ. Including invited guest faculties who had worked during the academic year 2023, then a copy of the order dated 1/6/2023 issued by the second respondent of invited faculty and also the order dated 10/11/2022. So you are specifically referring to the people whom you had invited under 1/6/2023. You have relieved them on 14/8/2023. And you chose to suppress that particular fact. Only because you wanted me not to grant an interim order in their favor. I will hold that. I will hold that if you had said with the existing faculty, the matter would stand there. You invited this by saying you will go with the invited faculty who were appointed on 1/6/2023. They were no longer in service. So you are guilty of making a false statement. I'll initiate proceedings. 195. ಮಾಡ್ಲಿ ಅಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ ಅವ್ರಿಗೆ ಆಸೆ ಇತ್ತಲ್ಲ, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಬಂದವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ ಇವಾಗ. By tomorrow, if you don't give me anything positive, there's no going back. You want some instruction tomorrow. Let us see. Either way, your affidavit will be filed tomorrow, right? You also please look into this. I don't know why this is happening in this particular case. It's beyond me. ಎಲ್ಲ ನನ್ಗೆ ಆಮೇಲೆ ಹೇಳಿ, ಇದೆಲ್ಲ ಆಮೇಲೆ ಮಾಡ್ತೀನಿ. ಇದು ನನ್ಗೆ ಬೇರೆನಾ? Decide the inquiry. Permission was granted. You take any action against the director? Yes.
Only for those who are actually taking that.
Give me the facts. Give me the facts. Professor. Of microbiology. Did you get the approval? The very same director gave you this. No, because it's. Yes. When was the objections raised? Where do you get that? 36. Yes. Yes. Did they stop? Twenty-three, 12/2009. What was the result of the inquiry? Where is that order? Yes. December 2010. What was the order? Charge is proved. Question consider ಮಾಡಲಿಲ್ವಾ? You have filed an affidavit thereafter? No, after this circular came in, requiring you to file an affidavit to claim non-practicing. ಕೊಟ್ಟಿದ್ದೀರಾ? What is your case, madam?
So, find out, I am going to that's it, finally turn to election, camera. Next, the very basic. And it is for evidence, but yes, working in front of taking. Repellent to the period was highly able
Yes.
my attendance to the period was
This is the reply to what?
our notice of
Inquiry.
when we gave the entire notice of
Where is the consideration of her reply that she had obtained permission by the inquiry committee?
this revision by the she has been,
Because during the course of the permission that she had permission from 2006 till she got the show.
and then the permission there, they have said, till you get permission complete.
Yeah, correct. From 2006 till 2009, she had permission to do outside practice. And that's what she has reiterated. Between 2006 and 2009 at the main.
But there she has been right. What in the nature of the lordship that another
Next year.
page 60.
Yes.
Page 64 is taking parity. It is the lordship. Dr. Sumangala. But we India Raja Pathe. India media some of ವೇತನದಲ್ಲಿ ಪಡೆದಿರುವುದಾಗಿ ಒಪ್ಪಿರುತ್ತಾರೆ ಹಾಗೂ ಮೈಕ್ರೋಬಯಾಲಜಿ ವಿಭಾಗದ ಪೂರ್ತಿ ಪ್ರಭಾರವನ್ನು ಹಿಂದಿರುಗಿಸುವುದರಲ್ಲಿ ಒಪ್ಪಿಕೊಳ್ಳುತ್ತದೆ. ಆದರೆ ನಿರ್ದೇಶಕರು ಭಾಗಶಃ ಮೈಕ್ರೋಬಯಾಲಜಿ ವಿಭಾಗದ ಪ್ರಭಾರವನ್ನು ನೀಡಿರುವುದರಿಂದ ನಿರಾಕರಿಸುತ್ತಿದೆ. ಸದರಿಯವರ ವಾದ ವಿವಾದಗಳನ್ನು ಕೇಳಿ ಪರಿಶೀಲಿಸಿದ ನಂತರ ಡಾಕ್ಟರ್ ಸುಮಂಗಲ ಇವರು 1-2-21-10-2009 ನಾನ್ ಪ್ರಾಕ್ಟೀಸಿಂಗ್ ಎಲೆವೆಂಟ್ 5,20,940 ರೂಪಾಯಿಗಳನ್ನು ವೇತನದಲ್ಲಿ ಪಡೆದಿರುವುದಾಗಿ ಒಪ್ಪಿರುವುದರಿಂದ ಸದರಿ ಮೊತ್ತವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಪಾವತಿಸುವುದಾಗಿ ಹಾಗೂ ಯಾವ ದಿನಾಂಕದಿಂದ ಖಾಸಗಿ ಪ್ರಾಕ್ಟೀಸ್ ನಡೆಸುತ್ತಿಲ್ಲವೆಂದು ಬಗ್ಗೆ ಅಫಿಡವಿಟ್ ಅನ್ನು ತಮ್ಮ ಸಂಸ್ಥೆಗೆ ಸಲ್ಲಿಸಿ ಆದ್ದರಿಂದ ನಾನ್ ಪ್ರಾಕ್ಟೀಸಿಂಗ್ ನಿಮ್ಮ ಸಂಸ್ಥೆ ನಿಯಮಾನುಸಾರ ಪಡೆಯಬಹುದಾಗಿದೆ. ಮಿಮ್ಸ್ ಮಂಡ್ಯದಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬೋಧಕ ಸಿಬ್ಬಂದಿಗೆ ನಿರ್ದೇಶಕರನ್ನು ಒಳಗೊಂಡಿದೆ. ತಮ್ಮ ಪ್ರತ್ಯಾರೋಪಗಳನ್ನು ಮಾಡದೆ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ she has filed the academic lodging and the amount was training. Earlier it was 5,20,940. Later, as per academic lodging, it was NHLW lodging, NHLW page ಕರೆಯಿತು. ಮತ್ತು ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಸ್ಥೆಯಿಂದ ಪಡೆದಿರುವ NPA ಮೊತ್ತವನ್ನು ಅವರ ಸಂಸ್ಥೆಗೆ ಪಾವತಿಸಿರುವಂತೆ ಸೂಚಿಸಲಾಗುತ್ತೆ. ಆದರೂ ತಾವು ಸಂಸ್ಥೆಗೆ ಪಾವತಿಸಲಿಲ್ಲ. ದಿನಾಂಕ 17/3/2010 ಸಲ್ಲಿಸಿರುವ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 17/10 ಖಾಸಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಆಗುತ್ತಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುವುದರಿಂದ 17/3/10 ಸ್ವಯಂ ಮಾಡಿರುವ 1,95,020 3,25,715 ಪಾವತಿಸಲು ಪಾವತಿಸುವಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗಿದೆ. The lordship bill has been collected as per the order of extract law. NHLP is not understand. They are collected. Lordship, other than this lordship, there is an allegation against the petitioner that he does not have the required qualifications to be a professor was, and when the inquiry was conducted,
What is the total amount record? 3,25,000 or 5,20,000?
It's already before the inquiry started.
Lecture? The petitioner was appointed by the professor and head of the department of microbiology in the Mandya Institute of Medical Sciences on 17/1/2006 by memorandum dated 17/1/2006. Clause 4 of her memorandum of appointment read as follows. It was thus clear that the petitioner could not undertake outside professional work unless she had taken permission of the director. Next. On 1/2/2006, the director who had appointed the petitioner granted a permission to the petitioner to practice outside the institute as per Annexure B. The contents of Annexure B read as follows. It is therefore clear that the petitioner was specifically granted permission as per a role request to work outside Mandya and after the working hours of the institution without hampering the work of the institution. It was also clearly stated that she would stop this outside practice in future if any objection were raised. Obviously, this permission is in relation to clause number 4 of her memorandum of appointment. In other words, specific permission was granted to the petitioner to practice outside the institute as provided in the memorandum of appointment. Notwithstanding the permission granted, on 31/8/2009, a show cause notice was issued to her stating that one Dr. A.M. Kirti, Associate Professor of Microbiology, had complained in writing against the petitioner that she was drawing non-practicing allowance right from the date of joining the institution. And on the basis of this complaint, the show cause notice was issued stating that drawing of a non-practicing allowance was against the rules. Next. In response, the petitioner submitted reply dated 22/9/2009 stating that she had received the show cause notice on 16/9/2009 and that she was informing the institute that she would not be practicing henceforth. It is thus clear that the petitioner, in consonance with the permission granted to her, informed the institute that she was stopping her outside practice in view of objections raised. Next, we are pertinent to state here that on 22/9/2009, that is the very date it is submitted, that on 8th of December 2009, notwithstanding the reply given by the petitioner, the show cause notice, the petitioner was served with an inquiry notice. Annexure No, that inquiry notice.
This is Miller. Page 42.
Fixing the date of inquiry as 14/12/2009. She was also called upon to submit her defense. However, even before the inquiry was concluded, on 23/12/2009, from Abide Annex H, an order came to be passed directing that our non-practicing allowance should be withheld. The inquiry constituted by against the petitioner culminated in the filing of an inquiry report in December 2010 in the following terms. Page 64. The inquiry report did not, however, consider the defense that she had taken up in her reply dated 1/11/2010 that she had been granted permission to practice outside Mandya as provided under the memorandum of appointment. The inquiry report basically stated that since the petitioner had admitted that she had undertaken outside practice from 1/2/2006 to 31/10/2009, she was liable to return the sum of rupees 5,20,940, which she had drawn as non-practicing allowance. It is stated by the learned counsel appearing for the institute that this order was modified and the amount of rupees 5,20,940 was reduced to rupees 3,25,715, taking into consideration that the petitioner had filed an affidavit on 17/3/2010, and thus for the period 17/3/2010 to February 2011, the amount that she had drawn was disregarded for the purpose of recovery. Learned counsel for the petitioner contends that once there was a provision in the appointment order itself for granting permission to the petitioner to practice outside the institute, and once this permission was granted, the question of the petitioner committing an illegality or acting in contravention of the rules would not arise, and therefore the drawing of a non-practicing allowance on this score cannot be found fault with. Learned counsel for the institute, on the other hand, contends that once the petitioner admitted that she had practiced outside the institute, her drawing of the non-practicing allowance would be improper, and therefore the order impugned cannot be found fault with. It is no doubt true that a non-practicing allowance is granted if a doctor sacrifices the opportunity to earn an extra income, and therefore if a doctor does practice apart from his main employment with an institute, normally, he or she would not be entitled to draw the non-practicing allowance. However, in a case where the order of appointment itself permitted a doctor to practice outside till some objections were raised, it is clear that that particular doctor was granted permission to practice outside. So in this case, the permission granted to the petitioner was to practice outside Mandya. And it is therefore clear that she was not permitted to practice within Mandya. Consequently, her drawal of non-practicing allowance cannot be found fault with, and there cannot be an order directing the recovery of the said non-practicing allowance collected by the petitioner. The inquiry which was conducted against the petitioner did not even take into consideration this particular defense taken by the petitioner, and merely because the petitioner admitted that she had practiced, an order of recovery has been passed. In my view, having regard to the facts and circumstances of this case, the order of recovery passed cannot be sustained. It is also to be noticed that, as indicated by the petitioner, the moment she was issued with the show cause notice, she has informed the authorities that she had stopped practicing. And this indicates that her intention was not to mislead the employer and collect an amount which she was not entitled. In the result, the impugned orders are quashed and the respondents are directed to return the sum of rupees, the whatever sum was recovered from the petitioner as non-practicing allowance for the period 2006 to 2009, within a period of 2 months from the date of receipt of a copy of this order. Seven. Yes. ಎಲ್ಲೋ ಹೋಗ್ತಿದ್ರ ನೀವು? ದಿನಾಂಕ 10/10/2006. ಇವಾಗ ಏನ್ ಮಾಡ್ತೀರಾ? Can you accommodate her? ನೀವು ಮಾಡ್ತೀರಾ ನೀವು? ನೀವು ಮಾಡಂಗಿದ್ರೆ I'll direct them to consider creating a supernumerary post. If you don't do it, then I cannot pass an order. Let us see if you can get a job without list on. By which time the learned counsel appearing for the university submits that the question of accommodating the petitioner is under consideration and would be considered in the next executive council meeting. It is also stated that if the council agrees to accommodate the petitioner, they would have to necessarily seek the permission of the government for the said step. In the night of this submission, relist, by which time the council for the university to submit the result of the consideration of the petitioner's case. In Madam Mulera? Before? Agilva ಅವರು? She is only surviving ಕಾಸಿನೂ ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆ. Money is still with you. In ಏನ್ ಫಂಡ್ ಅದು? Will dispose it of saying that she has to go and appear before the KGAD. The prayer in this petition is to direct respondents 1 and 2 to consider the representative of the petitioner and also for issuance of a mandamus, directing the respondents to furnish the details of the LIC deductions made in respect of the made to the account of late KP Shantaraju, the brother of the petitioner who died while in service. A prayer is also made for issuance of a mandamus to direct respondents 1 and 2 to settle and release all other monetary benefits, including group insurance, death fund benefit, cremation expenses, etc., in favor of the petitioner. In the pendency of this writ petition, on 8/4/2014, the petitioner was directed to meet the concerned official of the BBMP and to execute the related documents so as to enable the BBMP to furnish the same to KGAD and for further processing of the file. It is also noticed in the order dated 22/3/2017 that the documents had been executed and the BBMP had forwarded the same to the KGAD along with the service register of the deceased for settlement of family welfare fund and employees welfare fund, along with the communication dated 17/5/2014. On 5/3/2018, the constable of the petitioner was permitted to implead the medical officer for health, Jayanagar subdivision as fourth respondent. Since the fourth respondent was required to take action for release of the said funds. On 12/4/2018, it was ordered that if the petitioner approached the fourth respondent and furnished necessary particulars, the required documents and execute the bond as required by the third respondent, the fourth respondent would forward the same to the third respondent for further action. The counsel of the petitioner had then stated that the petitioner would visit the fourth respondent's office on 17/4/2008 and do the needful. However, Learned Counsel, appearing for BBMP Shri Muralidhar, contends that despite this order, the petitioner has not appeared before the fourth respondent, and as a consequence, the papers were not processed. In view of the above, this writ petition is disposed of, directing the petitioner to approach the fourth respondent and furnish the necessary particulars from our documents and also execute the bond as required to enable them to take further steps in the matter. If the petitioner were to approach the fourth respondent and do the needful, the respondent shall complete the process and ensure that the petitioner is given the benefits due within a period of 2 months thereafter. The petitioner will dispose of. Respondents and again. Actually, which is the order that is challenging? Relation of pass.
That performance. They were doing yes.
ಅಂದ್ರೆ ನಿಮ್ಗೇನ್ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಂಗಾಗುತ್ತೆ? ಸಪೋಸ್ ಐ accept your argument, no punishment at all. If I accept your argument, what is the punishment that you will get? When he was still in service, because he was not in service, Naragirli, what is the punishment that you will get? You ಅವನಿಗೂ ಅಲ್ಲ, ಅವನಿಗೂ ಡಿಮೋಷನ್ ಮಾಡ್ರೆ ನಿಮ್ಗೆ ಸಮಾಧಾನ ಆಗ್ತಿತ್ತು. ಇರ್ಲಿ ಬಿಡಿ, ಏನೋ somebody died because of your ಏನ್ ಡೆಸಿಗ್ನೇಷನ್ ಇದ್ದಿದ್ ನಿಮ್ಗೆ? ಅಲ್ಲ ಡಿಮೋಟ್ ಮಾಡೋದು ಅಂದ್ರಲ್ಲ, ಇವಾಗ ವಾಪಸ್ ಲೈನ್ ಬಿಡಿ, ಅಟ್ಲೀಸ್ಟ್ ಕೆಲಸ ವಾಪಸ್ ಸಿಗ್ತಾರ ನಿಮ್ಗೆ. If I modify the punishment, you are virtually going off without any penalty. Compassionate appointment ಕೊಟ್ಟಿದ್ದೀರಾ? Compassionate appointment ಯಾರು ಕೊಟ್ಟಿದ್ದೀರಾ? Thank you. His only grievances regarding parity, regarding punishment. He is accepting the finding of guilt, he is accepting the punishment imposed. ಅಷ್ಟೇ ಮಾಡಿ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ, ನನಗೂ ಅಷ್ಟೇ ಕೊಡಿ ಅಂತ. ಅಲ್ಲ, ಅವನು ಮಾದಪ್ಪ ಅಲ್ವನ ಹೆಸರು?
ಸೊ ಅವ್ರದ್ದು ರಿಪೋರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಲೈನ್ ಲೈನ್ಗೆ ಹಾಕ್ಬೇಕು. ಆದ್ಮೇಲೆ ಅದಾದ್ಮೇಲೆ ಮಾದಕ ಫೈಲ್ ರಿಪೀಟೇಷನ್ ಸ್ವಲ್ಪ ಡಿಫ್ರೆಂಟ್ ಇತ್ತು ಮ್ಯಾಟರ್
ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ತಾನೆ, ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ತಾನೆ.
ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿ
The event is one. Both of them had allowed one person to operate the transformer, which resulted in his death. So ಇಬ್ಬರಿಗೂ ಒಂದೇ ಪನಿಷ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ ಅಷ್ಟೇ ಅವ್ರು. Demotion ಮಾಡ್ಬಿಡಿ, no benefits, only for the purpose of pension. Give him the same pension in that lowest pay scale in MM2. Whatever was granted to Madhappa. No other benefits. He will not get any other benefits. Only for the purpose of pension. See if you can order ಮಾಡ್ಬಿಡ್ಲಾ. They won't accept. I'll pass an order. ಅವ್ರು ಒಪ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ. They have to do. Yes.
Third.
Deputy registrar ಅಲ್ವಾ? Yes. Yes.
Modifications.
Yes. Yes.
Was given the word of the. By period of time.
5. Notification says 5 years. Where is the corrigendum? Notification 16/7/2012. $18.
Also found in Seniority.
35 plus 10 years. If they have worked in the government department. Yes. All right.
The beneficiary of this notification.
No, just tell me how you are qualified. Your appointment is under challenge on the ground that you are not entitled for this 10-year relaxation.
Also, this notification or I am entitled for.
No, this 10 years is available when kindly come to page 66. It's not granted to everybody.
Granted to everybody.
Kindly read.
Petition is also with each year is.
We'll come to the petition afterwards. Kindly read column clause 1.
With the.
Page 66 clause 1. ಅಭ್ಯರ್ಥಿಯ ಕೇಂದ್ರ ರಾಜ್ಯ ಸರ್ಕಾರದ ಅಥವಾ ಸರ್ಕಾರದ ಸೌಮ್ಯ ನಿಯಂತ್ರಣಗಳಲ್ಲಿರುವ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರ ನಿಗಮಗಳಲ್ಲಿ ಹುದ್ದೆ ಹಿಂದೆ ಹೊಂದಿದ್ದಲ್ಲಿ ಗರಿಷ್ಠ ವಯೋಮಿತಿಯನ್ನು only in the of those particular class, central or state government ಅಥವಾ ಸರ್ಕಾರದ ಸೌಮ್ಯ ನಿಯಂತ್ರಣದಲ್ಲಿರುವ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರ. The salary grant is given to the institution. You are never an employee of the government there.
If the institution is following a statutory rules, but if the state is thinking of.
This exemption is granted only specifically to those people who are serving the government directly, not the persons who get the benefit of a salary grant. Specific ಸೌಮ್ಯ / ನಿಯಂತ್ರಣದಲ್ಲಿರುವ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರ, local authority. You cannot consider a school as a local authority. Can't be a local authority, Mr. Chandrasekhar.
It is an aided institution, but any institution not following the statute, but prescribed not by the government. But it is the state within the meaning of article 12.
You are claiming,
You cannot stay there.
you are claiming the benefit on exemption.
Even if you have brought up.
Not in terms of,
It is not the. They cannot. Education has been issued, but by the government, that is not. Resolution your lordship is guiding it.
ಎಲ್ಲಿ?
Resolution passed by the syndicate. The lordship is guiding it, Lord. The notification issued by Lord, Section X.
Yes. HRH's proceedings.
They have referred to the Lord as syndicate resolution dated 31/8/2000. Page 82. Your Lord.
ಎಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ?
Referred to the Lord as notification of the syndicate Lord dated 31/8/2012.
What is this resolution?
Say Lord, if the candidates are not similarly situated elsewhere, may also be considered. But
They were available here. He was there.
he is also not working Lord in a private university, in a private institution. But he cannot contend like this.
So both of you will not get the job there.
But as far as I am concerned, it is only the pipeline of Lord directly not by appointment.
If you are not eligible, you are not eligible. That is all. If he is not eligible, he is not eligible.
The
Yes.
candidates are not available, but if there are many candidates.
That is not their stand. That is not the stand of the university. But because
They are stated. The recommendation made, Lord, they are referred to Lord, this qualification.
let us see their counter whether they have said that. The resolution may not have any effect unless the C&R rules provide for such relaxation. Not by way of a syndicate. Then what is the base of a C&R rule if the syndicate goes on changing their stand?
They are only relaxing. They are only relaxing the condition.
That should be available in the statute. That power should be available.
Relaxation is not conferred upon. Third point, where is the resolution? If you are very well, all
ಇಲ್ಲ ಇದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅಷ್ಟೇ ಅದು. ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಗಲ್ಲ ಇದು. It's not a question. Kindly read clause 3 here in page 32 that he has read. ವಿಶ್ವವಿದ್ಯಾಲಯವು ಕರೆಯದ ಯಾವುದೇ ಬೋಧಕೇತರ ಹುದ್ದೆಗೂ ನಿರ್ದಿಷ್ಟವಾದ ಅನುಭವ ಇಲ್ಲದಿದ್ದಾಗ ಸಮಾನಾಂತರವಾಗಿ ಪಡೆದಿರುವ ಅನುಭವವನ್ನು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್, not exemption for working in a aided school.
speaks of experience only.
This is not experience. This is an exemption. This is an exemption granted if X, Y, and Z applicants work in a government institution. That is,
relevant statutes should as per the age. Because not approved by the chancellor.
Clause,
This is document you want to be carried.
clause,
Age you will want to be carried. Page 18.
in the statutes. ಯಾವ statute ಹೇಳಿ sir?
So statute of the
The statute number.
private.
9 ಅಲ್ವಾ? 9 age limit for appointment. 9 ಅಲ್ವಾ? For SC/STs. 9 is the age limit for appointment. 9 ನೋಡಿ first.
The voter of masses is very.
By promotion from the cadre of assistant registrar, if suitable candidates are not available for promotion, then by direct recruit. ಅಷ್ಟೇ.
The holder of master is awarded a recognition minimum of 5 years of service in the theatre of but it is not a government, but it is not the working.
Exemption regarding age limit is clause 9.
Yes.
Clause 9 states in those 4 categories, if you're working, you have this 10-year relaxation. If you're not there, you're not there. If he is not there, he is also not.
But as far as his petition is concerned, but he cannot question this because what he is a beneficiary. But on the question of doctrine of acquiescence, he cannot question or present to service that job. Because he is also not getting the same benefit what he was of the age of 39. If that is repetition is rejected, what of that problem? The question of going into high qualification with reference to the age relaxation is not right, because it is not a petition product over. But I am relying upon the judgment of the honorable Supreme Court. Executive question about identity. Yeah, has to be right. That I have to be over. The honorable Supreme Court said, that it is only a reason, a person accused. If he is not a person accused, that was the qualification. He was also not claiming the same benefit under the same qualification, but he was 39 years. He also claimed the benefit of the relax. If that goes forward, the repetition will have to.
All the time.
Yeah, because you have to kindly think of. Paragraph 20. Whole line. The petition is also a. The background order that he takes is document guidelines regarding age.
He is not a third party, he is an applicant.
If claiming the benefit,
Maybe so, he is an applicant, he has the right to challenge the appointment.
not the ground, but not on the.
In whatever ground, he has the right to challenge. The question of locus standi.
The petition is liable to be rejected or not on the doctrine of such.
There is no question of doctrine of acquiescence. He is challenged it saying he could not have been appointed. We will examine whether he is.
He is also not 39 years. Not the same. I should have worked there.
I am not saying all that. I'm only saying you became eligible to be considered for recruitment only if you had worked in those 4 institutions referred therein, by virtue of which you get an exemption.
Yes.
That is all. If you have not worked, you don't get the exemption. That is all.
That is the reason.
You are linking it to experience. I'm not linking it to experience. Both of you may be qualified, but your age bar.
Is giving relaxation or on the basis of the same qualification. But which he is complaining about the exemption given to me in return to pay is not paragraph 10 of the law. He
Yes.
said not it's not given to me. Now pay is not what is his age. He was 39 years.
I
He
will,
was also not eligible.
I will consider your case. This is your only argument, isn't it?
But my contention is not by virtue of doctrine of acquiescence, not he cannot argue for the and there is no other question which can be gone into by this honorable court, because there will be no other ground available for in this petition to be considered, because this petition both nothing remains for to be considered. Whether I am eligible or not, maybe it may be a case in a bit of go or somebody files bit of go or saying that I have no qualification. But that is what the honorable Supreme Court has said.
All right. I'll
There was a
consider.
question with regard to what would be the nature of a review that can be asked about in petition like this. And the Honorable Supreme Court in paragraph 74, you are.
Yes.
This petition is also not a writ of cover. The service jurisprudence, it is said that it is for the aggrieved person, not as a appointee to assess the legality of the offending act. Once this petition goes forward on this doctrine forward, then there is no other person not being required to be done. Therefore, Lord, this petition is liable to be rejected, Lord, to be by
Yes.
To be guided, Lord, with age. May I request you, Lord, to kindly see the application made by.
Yeah. 39 years.
39 years.
Yes. How did he claim exemption? How did he claim exemption?
But says,
Where was he working?
he was working for he was working in a private college, private institution, for which was part-time. If your lordship would kindly see by instructions, Lord, if your lordship notices, Lord, the date on which Lord he was working.
Where was he working, Abhinav? Does he come within the exemption or not? Where was he working? Where were you working, Nagaraj?
But if the additional document is there,
Which? It's the university, isn't it? Karnataka Samskrita Vishwavidyalaya.
because I was.
This is a page 37 is an appointment of this Vidwan M. Shivamurthy. 37. Half page correct. Petitioner, I think, is Shailashri, alva? Gangadhar. Ande kotrad nange. Yes. The government department, isn't it? Then Allah. Page 37.
Next page, not page 38.
He was working in whereas
From 95.
no, he was working in a college. I'm asking about the petitioner.
He was working. Yes,
ಏನ್ ನಾಗರಾಜಪ್ಪನವ್ರೆ?
they are working in university.
You are not sure, you don't have the records, you're simply saying,
Understanding in university is.
I understood your understanding. I have my own understanding. So you tell me what exactly was he would do. Tell, va? Observe. If you are not employed, if you are not employed in university, you are out. I note with the facts code is saako. What about the other case? If he is eligible, not eligible, hoitala. Of your understanding. Second one.
Page number.
Yes.
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 He says, column number 3, he says, he was working or he was studying. Because, can we mark that the year in which he was working?
Let me get a clarification from them.
Was working or he was studying or 2007.
2004.
Column number 3.
That is diploma.
Column number 5. ಇದೆಲ್ಲ study ಮಾಡ್ತಾ ಇರೋದು. But he gives a certificate when you are studying the certificate of experience is falling or not within these periods.
Maybe so. If he is permitted to study while he is working, how can you say?
No, it is not like that. Put that for.
What is he?
Put that for. After they ಹೇಳ್ತಾರೆ ಅವರು ಏನೋ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇನ್ನೊಂದು not he was working permanently.
What you say is correct. He will also not get the job. That is all. ನೀವು ನಿಮ್ ದಾಖಲಾತಿ ಕೊಟ್ಟಿದ್ರೆ ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಈಗ ಆರ್ಡರ್ ಮಾಡ್ತಿದ್ದೆ, ನೀವು ಹೇಳ್ತಿಲ್ಲ, ಅವರು ಹೇಳ್ತಾ ಇಲ್ಲ. ರಿಸರ್ವ್ ನೀವು ಕೊಟ್ಟಾಗ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ಅದರ್ ಕೇಸ್, ವೇರ್ ವಾಸ್ ಹಿ ವರ್ಕಿಂಗ್?
He says it is not correct. The absence of challenge to the contempt.
No, I am accepting that. I am only on this ground. That is all. Whether needed institution comes within the purview of that exemption or not. ಇದೇನಕ್ಕೆ ಕೊಟ್ರಿ ಮಂಜುಶ್ರೀ ಇದೇ ಕೇಸ್ಗ? ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಪ್ರೂವ್ ಆಯ್ತಾನೆ, ಅಸೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾನೆ ಗವರ್ನರ್. So there is also a corrigendum which you have not challenged. ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಎಲ್ಎಸ್ಟಿ ಕೇಸಲ್ಲಿ? What is the name of the third respondent? Shivamurthy. Where was he working? ಅನುದಾನಿತ ಸಂಸ್ಥೆ. ನೀವೆಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರಿ? But she was within that, she was within 35 years. You are beyond 35 years. So if you don't get, if you don't have that age eligibility, other I'll consider. But ನಿಮ್ಗೆ age ಅಂತೂ ಇಲ್ಲ. ಮುಗ್ಬಿಡ್ಲಿ. Yes. What was the recruitment for? ಏನ್ ಕೆಲ್ಸಕ್ಕೆ? Section officer ಏನಿತ್ತು qualification under the C&R? $58. Page number 60 ಇರಬೇಕು. Serial number? Serial number ಹೇಳಿ. 6. Degree from a recognized university and minimum 5 years. He got the degree in 97. 97. 2000. Yes. ಏನ್ 5 years ಏನು 5 years ಏನಿಲ್ಲ ಅಂತ? Indicator of senior assistant. Indicator of senior assistant ಅಂದ್ರೆ ಏನು ಅರ್ಥ ನಿಮ್ ಪ್ರಕಾರ? ಎಲ್ಲಿದೆ ಸೀನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್ ಇದು? $28. Page? Number 22 ಅಲ್ವಾ? Very by promotion from the cadre. If eligible candidates are not available, then by direct recruitment. Otherwise, there is no experience required. So this will not apply. Minimum of 5 years of service. It's only instead of promotion. That is all. So that will obviously have no relevance for the purpose of this section officer post. See this by promotion from the cadre of senior assistant. If how can she be having experience? How can she have experience as a senior assistant? Then correct, but how can you rely upon clause 3, which relates to the experience of 5 years in the cadre of senior assistant? That is impossible. So only degree is all that is required. In case this service of 5 years is in case you want promotion. So long as a person who's got a degree, they become eligible to be recruited as a section officer. Yes. You are amending the C&R rules. C&R rules, normally both of you would not even be eligible to be considered. Just because there was nobody there, you got a chance to be recruited. You will also not be eligible for senior assistant. Where were you working as senior assistant? It is specific in the cadre of senior assistant. Then that is not, you can't amend the C&R rules to suit your. ನೀವು ಇಬ್ಬರಿಗೂ ಸಿಗಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ. ನಿಮ್ಗಿರೋ ಪ್ರಾಬ್ಲಮ್ ಅದಲ್ಲ ಏಜ್. ಫಸ್ಟ್ ಅದೇ ಅಷ್ಟೇ ಬರೋದು ನಿಮ್ಗೆ. ನಿಮ್ ತೊಂದ್ರೆ ಬರೋದು ಏಜ್. You are beyond 35 years. You don't work in a university or a government department. 10 years birthday, but you're still not working in the institution specified therein. Yeah, aided college. You satisfy him and ask me to withdraw that petition. I will not do anything. If they want to re-notify, I'll direct them to give you exemption for that age. ನಿಮ್ ಕೆಲಸ ಸಿಗಲ್ಲ ಅಂದ್ರೆ ಅವ್ರನ್ನು ಹಾಳು ಮಾಡ್ತಾರೆ ನೀವು ಅಷ್ಟೇ. ನಿಮ್ಗಂತೂ ಸಿಗಲ್ವಲ್ಲ. How many applicants were there? So if that goes, they'll have to reconsider from amongst the other eligible candidates. ಬಿಡಿ ಮಾಸ್ಟರ್ಸ್ ಡಿಗ್ರಿ ಇದೆಯಲ್ಲ, reconsider along with other eligible candidates. ಏನ್ ಮಾಡ ಅವ್ರು ಬಂದಿರ್ತೀಗ ಕೋರ್ಟ್ಗೆ. If there are only 2 applicants, I had no difficulty in saying consider your case because you are the only remaining candidate. If there are 3 other people other than you, suppose they have more merit than you, then can I allow that to happen? You are taking away somebody's job, so you should also be a bit that how many years after 10 years they will not get any employment now. ನೀವು 10 ವರ್ಷನ ಮಾಡ್ಕೊಂಡಿದ್ದೀರ, ಅವ್ರು ಇರೋನ್ ಕಿತ್ಕೊಡ್ತಿರಲ್ಲ. So the equity is on their side. ನೋಡಿ ಯೋಚನೆ ಮಾಡಿ, ನನ್ಗೇನಿಲ್ಲ, ಬಟ್ ನಿಮ್ಗಂತೂ ನಾನು ಡೈರೆಕ್ಟ್ ಆಗಿ I can't ask them to appoint you along with other eligible candidates. ಏನಾಗುತ್ತೋ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ, ಬಂದು ಮೆನ್ಷನ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ. Please keep that in mind, because if you don't get the job, you will get any benefit by ensuring that they will lose their job. Adonದು ನೋಡ್ಕೊಳ್ಳಿ. ಎರಡು ಕೇಸಲ್ಲೂ 5 ಜನ ಇದ್ರ in both the cases? ಅವ್ರು ಬಿಡಿ, ಅದು ಇಟ್ಕೊಳ್ಳಿ ಅವರು. How many applicants were there in that case? Along with others ಅಷ್ಟೇ. ನನಗೇನು I have no difficulty in quashing their appointment. You will not get the appointment, so you take a decision whether it's worthwhile removing them after 10 years. It's in your hands. ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಸಾಕು. What equivalence? You have to amend your notification. Not now. Opposing you. Who's opposing you? What is annexure N? N. When were you appointed? When were you appointed? Oh, but when you were appointed, there was no sanctioned post.
No, it was there. Because initially, I was hired with daily work. I got also
Page numbers ಏನು ತಪ್ಪಿದೆ ನಿಮ್ದಲ್ಲಿ, ಯಾವ ಪೇಜ್? Next year. What happened to this approval? Subject to the approval, ಕೊಡ್ಲಿಲ್ವಾ? Approval ಕೊಟ್ರ ಕೊಡ್ಲಿಲ್ವಾ appointment? Be correct on facts. Who appears for the institution? This annexure C talks about subject to approval by the DDC. Was this approved? Was this appointment approved? Was the temporary appointment approved? Where is the next appointment order? On then, she was appointed as how many posts were vacant? Where is it admitted that the sanctioned post as torches? Hello, Tidra. Reading. Lecture why? ಎಷ್ಟು ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇತ್ತು ಹೇಳ್ಬಿಡಿ ಅವಾಗ 93 ಎಷ್ಟು ಜನ ಇದ್ರು ನೀವು ನಿಮ್ಮನ್ನ ಬಿಟ್ಟು how many sanction posts are available in 1993 when she was appointed? If there was only 4 teachers, 4 lecturers in mathematics in year 1993, then it is against a sanctioned post. Sanction post ತೋರಿಸಿ ಜೋಯಿಸ್ರ ಮಿಕ್ಕಿದ್ದೇನೆ ಬೇಡ ನಾ ಇದ್ರೆ ತೋರಿಸಿ ಸುಮ್ಮನೆ ಯಾಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪೇಜ್ when did you file it? Page 17. What is this? Weekly workload. There are 5 people as on. What is the total amount of sanctioned posts? What is the total amount of sanctioned posts? Are you sure there are only 4 sanctioned posts? ನೀವು ಕೆಲಸ ಮಾಡ್ತೀರಾ ನೀವು ಅಲ್ಲಿ? Still working?
What was not available in that state.
File an affidavit. File an affidavit. File one. It is the condition of the petitioner that she has been working as a lecturer since 1991. Since 1991 as a part-time lecturer and as a full-time lecturer from 1993. It is his contention that even according to the order of the revision authority, the petitioner was working against a sanctioned post, but since this is contention that the petitioner was working against a sanctioned post, but the process of selection was contrary to a government order. The appointment orders which have been produced by the respondent institution indicate that the petitioner was appointed in the year 1991 as a temporary basis, as a temporary lecturer, as a temporary part-time lecturer, and the same was subject to the approval of the Deputy Director of Collegiate Education, Bangalore. The second order of appointment dated 13/9/1991 also states that the petitioner was appointed as a temporary part-time lecturer, and the appointment is subject to the approval of DDC. The other appointment order dated 18/7/1982 is also to the same effect. It is however admitted that the petitioner was working as a full-time lecturer since 1991. In the light of the above, the management is directed to file an affidavit as to the number of vacant posts that were available in 1991 and 1993 in mathematics, and the number of and the lecturers who had been appointed / working as either full-time lecturers or part-time lecturers during that period of time. The affidavit shall also state whether the temporary appointment made with annexure R1, R2, and R3 did get an approval from the DDCE Bangalore. Released on. I've said it is their contention. You will file an affidavit stating what is the amount of posts available in 91, 93, and what happened to the approval that you had sought for. So when you appointed them, you did inform the department. So if the department did not oppose that, now they cannot be permitted to say it's an illegal appointment, or ನೀವು ಯಾವಾಗ್ಲೂ ಹಿಂಗೆ ಮಾಡ್ತೀರಾ ನನಗೆ ನಾನು ಮಾತಾಡಕ್ಕೆ ಅವಕಾಶ ಕೊಡಲ್ಲ ನಾನು. If the department did not object to all the 3 appointments, then I'll have to presume that the department had no objection, it was a sanctioned post. Since you are not being, whether it's part-time or not, why would the department grant you approval? It was not a, so for 10 years, if you keep them on a temporary basis, you can get away with it. Let us assume she was working on unaided post. Can you keep her as a temporary lecturer for 10 years? That's why Supreme Court said if you do all that, you will have to regularize them. First file the affidavit, then I'll record. Released. Other matters I'll repeat. You attempt on it, Alva. Just in a pair. 56. ಯಾವ್ದ್ರಲ್ಲಿ? The order that is challenged here, Mr. Goodman. What was the next? What is the challenge here? What has happened pursuant to annexure C? You appointed them. Last week I ಕೊಟ್ರಲ್ಲ ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂತ Germany. What can you do if the government is not supporting you? Very good. Where is the affidavit? The government says that the reservation is not in accordance with the reservation policy. What is it that you and I can do? They have said it already.
Opinion. Government is not an advisory. Cannot find it.
Now, paragraph 4, it says is to be withdrawn and fresh notification is to be issued. So you may have to challenge it if you're agreed by this particular. No, the direction is to withdraw.
It is the nature of an opinion. Two officers of the government. We have done the recruitment with the capital of the repair of.
I have my doubts. ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಯಾಕೆ ಅಡ್ಜರ್ ಮಾಡೋದು? Since they have taken a decision, how can you? Day after tomorrow. Friday last birthday, but ಅದಕ್ಕೆ Thursday ಹಾಕೋದು. Ask him to take a decision, or else I'll take a decision on the basis of this affidavit. Whatever they want to do, ask him to do it by Thursday. Thursday. Early first out the writ petition idre tane impleading. Because the affidavit came about, this argument came about. But had the affidavit not been filed, I would have heard the arguments on merits. Correct, but the advocation came and said that they have taken a decision. Direction is. I don't know. They've taken affidavit. We don't know. We don't know. It's an autonomous body. They want to work under a statute. Good. Either way, somebody has advised them to come and file an impeding application. Thursday. DVR ಗೆ What are you challenging here? Next sir, L. L. Argument ಮಾಡಿದ್ರಲ್ವಾ ನೀವು? Who challenged this order granting him that sanction to his post on 2012-2010? 1997, this Parameshwarappa was admitted to salary grant. Then 2012-2010, this gentleman, the petitioner, was admitted to grant. This nobody has challenged. It was not challenged. It has become. Without this order being revoked, modified, annulled, you cannot deprive him of the right that he got under 2012-2010. That is all. Where is it withdrawn? Where is it withdrawn? Show me the order by which. Show me the order by which this 2012-2010 admitting him to salary grant has been revoked by the government. Which? Which? Report by Dinanga. Show me if there's a government order revoking the government order 2012-2010. You know better than me. Please show me that. Please show me that order. That is all. Show me that order so that I can use that against him. 23? I think that this order is dated 20th of December 2010. There can't be an earlier order. 23? Where is it? Yes. Withdrawal. WP 31828. What is the order that was passed on 23/7/2012? It has not been cancelled. An order of recovery is made. There is no order, Vijay Kumar, revoking his post being admitted to salary grant. All it was needed was to recall this order after hearing him. That is all. That has not been done. No, not now. without modifying 2012-2010, they cannot give it to you. And you did not challenge it. You did not challenge the order dated 20th of December 2010. You did not challenge it. ನೀವು ಅಲ್ಲೇ ವರ್ಕೌಟ್ ಮಾಡ್ಕೊಂತ ಹೋದ್ರಿ, ಅಲ್ಲೇ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ರಿ.
They have redone the entire issue.
Consider representation should be rejected simply on the ground that you have not challenged that order. That is all. If you have not challenged them,
This is the representation.
correct.
Receiving representation is still not okay. At least-
How can that be done? Oh, no. So without there being a challenge, consider. Therefore, you should have immediately challenged that particular order.
Representation was considered investigated. The authorities report to the status quo. And not to the notice that the error has been committed from wrong. That is what is the record shows. I'm not talking about the record shows. that-
An order admitting a post to salary grant is a solemn order. So long as that order is not in any way revoked or modified by way of considering your representation, it cannot be revoked. It is a valuable right granted to him. You are taking away that right. ಅದೇ ನೀವು ಅವರು ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರದ್ದು ಅವಾಗ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಸಾಲ್ವ್ ಆಗ್ತಾ ಇತ್ತು.
Only in the stuff of that. Legally exact.
So sue them for payment of the salary equivalent to that of us. ಅವ್ರ ಹತ್ರ ಮೋಸ ಮಾಡ್ರಿ ನಿಮ್ಗೆ. It's not a technicality, Vijay Kumar. I would be the last person to even think about technicalities.
When that order was stayed, investigation should be there.
Suppose now you have granted this particular order. 2 years afterwards, he makes one more representation. They hear you and pass an order in this favor. What would be your argument? What would be your argument?
Investigation that has been conducted before the recommendation.
Right.
But it is not that they are merely constructed.
Getting
Investigation because of the our recommendation.
ಅವ್ರು 11 ವರ್ಷ ಸಂಬಳ ಬರ್ತಾ ಇದ್ದಿದ್ದು ಇವಾಗ ಒಂದೇ ಸಲ ಹೋಗ್ಬಿಡುತ್ತೆ. ಹೌದು 2010 ಅಲ್ಲಿ ಬಂದಿದ್ದು 2021 ಅಲ್ಲಿ ಹೋಯ್ತು ಅಂತಂದ್ರೆ ಹೋಯ್ತಲ್ಲ, 11 ವರ್ಷ ಸಂಬಳ ಹೋಯ್ತು. ಅವ್ರಿಗೆ 11 ವರ್ಷದ ಅವ್ರು ಬಂದಿದೆ ಹೋಗ್ಬಿಡುತ್ತಲ್ಲ. You are powerful, you can catch hold of them and get another post of. You won't have got this sort. I will direct them to accommodate you against that post, not against him.
I do not belong to see.
Then they will not grant it to him also. For what? You give me a way out to direct, I'll direct them. I have no problem. If you are eligible, I'll direct them to consider your case. I will make that observation. Since the government has found that you are also eligible, the government may consider admitting you to salary grant in view of the fact there's one more post available. Adilwala, you were in the you're very much in the institution. You used to also sleep over the matter. But much country ಏನೋ ಆಗತ್ತೆ ಅಂತ. ಅಷ್ಟೇ ಅಲ್ವಾ? ಹೌದು.
Last to guide clearly because I am not challenging in one order that cannot be accounted behind.
The petitioners before this court challenging an endorsement dated 29/10/2021 by which it has been stated that the petitioner's post would not be eligible for a salary grant. Which was the first writ petition? The petitioner herein filed WP 31828/2012 being aggrieved of a communication dated 23/7/2012 whereby this salary was withheld. This court by an order dated 28th of September 2012 observed that since the matter was pending before the Commissioner, Department of Employment and Training, the petitioner could approach the Director, Commissioner for a redressal of his grievances and accordingly proceed to dispose of the said writ petition. The fourth respondent herein had also preferred WP 27221/2015 before this court, challenging for a direction to be issued to the Joint Director / Commissioner Employment and Training to consider the representation dated 13/10/2013 and 4/5/2015, whereby the petitioner was seeking for a salary grant. This court by an order dated 19th of August 2015 disposed of the writ petition by directing the Joint Director / Commissioner to consider the petitioner's representations dated 13/3/2013 and 4/5/2015 in case they had been received by them. Pursuant to the said order, ಇನ್ನೊಂದು ಈ ರೀಟ್ ಪ್ರಶ್ನೆ ಯಾವುದು? ಜೆ ಏನು? No, pursuant to this annexure. Pursuant to this order passed in WP 27221/2015, an order was passed on 13/6/2018 holding that refusing of an order admitting the post of the sixth respondent to a salary grant with effect from ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ರದನ್ನ what was this order? What is this WP 22930? Maybe pertinent to state here that the petitioner had also preferred WP 22930/2017, seeking for a direction to release his salary with effect from 1/5/2012. And this court by an order dated 19th of September 2018 directed the respondents to consider the representations and pass appropriate orders. Pursuant to the said order, an order came to be passed on 27/2/2019, holding that the petitioner's post could not be admitted to a salary grant since the post had been reserved for a scheduled caste. This endorsement was challenged by filing WP 798/2019. This order as well as the earlier order dated, were both challenged by the petitioner in WP 798/2019. This court, by an order dated 15th of July 2021, allowed the writ petition and quashed both the orders dated 13/6/2018 and 27/2/2019, and directed that those orders be read as show cause notices, and the petitioner was granted liberty to file his reply within 6 weeks from the date of receipt of a copy of the order. Pursuant to the said order, the impugned order has been passed on 29/10/2021, holding that the petitioner's post was not entitled to be admitted to a salary grant, and the post held by the sixth respondent was entitled to a salary grant. In this order, which is impugned, it is stated as follows. As could be seen from the above, the post that the petitioner was holding was admitted to a salary grant on 20th of December 2010. Admittedly, this order admitting the petitioner's post to salary grant was not challenged by the sixth respondent. Furthermore, and more importantly, this order admitting the petitioner's post to a salary grant has neither been revoked, modified, or varied by the government. If an order by which the petitioner's post, which was admitted to salary grant, had remained unchallenged for more than 11 years, the government by the impugned order could not have come to the conclusion that the petitioner's post was not entitled to be admitted to salary grant, and it was the sixth respondent's post which was entitled to a salary grant. In other words, an order by which the petitioner was held to be entitled to a salary grant, having not been challenged and having attained finality, cannot be undone in the guise of considering the representation of the petitioners and holding that the sixth respondent was entitled to the salary grant, even when the sixth respondent had not even challenged the said order. In my view, therefore, the impugned order dated 29/10/2021 will have to be quashed, and the respondents are to be directed to give effect to the order dated 2012/2010 by which the petitioner's post was admitted to a salary grant, and pay the petitioner the requisite salaries, if not already paid. Then counsel for the sixth respondent submitted that apart from two posts, there was yet another post which was vacant and which could also be admitted to salary grant, which has already been admitted to salary grant. Then counsel submits that the government may be directed to consider the case of the sixth respondent for admission to salary grant, since that post has not has remained unoccupied for several years now. In my view, since it is stated that an aided, since a post to which is admitted to salary grant has remained unoccupied for several years, it would be appropriate to direct the state government to consider the same and attach the sixth respondent's post to the said salary grant, subject to the above. ಯಾವುದೋ ಒಂದು ಅಟ್ಯಾಚ್ ಪೋಸ್ಟ್ ಇದೆ ಅಂದ್ರೂ ಅದನ್ನ ಮಾಡ್ತಾ ಹೇಳ್ತೀವಿ. Petition according to the statute. ಪತ್ರ ನಿಮ್ಮ ಹತ್ರ ರಿಕವರ್ ಮಾಡ್ರೆ ಮಾತ್ರ ಅವ್ರು ಕೊಡೋದು. 2012 to ಅವ್ರಿಗೆ ನೀವು ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿ ಅವ್ರ ತಿರ್ಗಾ ಕಾಸು ಬರಲ್ಲ. ನಾನು ಆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಗೆದ್ದು ಸೋತಂಗಾಗತ್ತೆ, ನೀವು ಸೋತು ಗೆದ್ದಂಗಾಗತ್ತೆ. No, if you do that, then there'll be a problem for him.
I don't think they will have any problem in accommodation. He has also.
Will you undertake not to challenge his salary grant and then I'll make that concession? You will not, you will accept. Counsel for the sixth respondent submits that the sixth respondent has drawn the salary from 2012 till date. So he also submits the sixth respondent whose forego is right to claim a salary grant which is admitted to the petitioner's post if no order of recovery is made against him. So since the sixth respondent has accepted the salary grant given to the petitioner's post, in my view, it would be in the larger interest of justice and equity to direct the state respondent not to recover the same from the petitioner, from the sixth respondent. ನಿಮ್ಗೂ ಸಿಗಲ್ಲ ಅಷ್ಟು ವರ್ಷಕ್ಕೆ. ಇನ್ಮೇಲಿಂದ ಹೋಗಿ ಹಿಂದಲಿಂದ ತಗೊಳ್ಳಿ. ಅಷ್ಟು ಬಿಟ್ಬಿಡ್ತೀನಿ ಬಿಡಿ, ಅಷ್ಟಕ್ಕೆ ಬಿಟ್ಬಿಡ್ತೀನಿ ಬಿಡಿ, ಅಷ್ಟಕ್ಕೆ ಬಿಟ್ಬಿಡ್ತೀನಿ. ಅವ್ರ ರಿಕವರಿ ಸ್ಟೇ ಮಾಡಲ್ಲ. ನೀವೇನ್ ಇಫ್ ಯು ಆರ್ ಏಬಲ್ ಟು ವರ್ಕೌಟ್. I will not say anything. No recovery from him. That is all. I will not say don't pay it to you. I am allowing your petition and quashing that order. I am only saying that no recovery from him. That is all. ಅದನ್ನೇ ಹೇಳಿದ್ದಲ್ವಾ? That is what I said. From 2012 to 2018, from 2012 to 21 years work, and ನೀವು ವರ್ಕ್ ಮಾಡಿದ್ದೀರಾ, ಬಟ್ ಅವ್ರ ಹತ್ರ ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ ಅಂತ ಹೇಳಿದ್ದೇನೆ ಅಷ್ಟೇ. ನೀವು ಕೆಲಸ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಮ್ಮಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ನಿಮ್ಗೆ. ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ವಾ? The grievance of the petitioner that he has not been paid his salary from 2016, 1/6/2012. If that is so, the respondents are directed to pay the salary to the petitioner in view of the fact that the order impugned has been allowed, has been quashed, and it is held that the order by which the petitioner's post was admitted to a salary grant has attained finality. ಹೇಳಿದ್ನಲ್ಲಿ has accepted the order ಅಂತ ಅಂದ್ರೆ in view of that only this is given. This condition within 3 months. What is the next RG? Page na? Confirm ಆಗಿತ್ತಾ ನಿಮ್ದು? Then Mangalore SEZ then company net. This one. When were you appointed? When were you appointed? 2010. For how many years she for 12 years she worked? Day after tomorrow. Day after tomorrow the orders list. The 4:30 ಹಾಕೊಳ್ಳ ಅದನ್ನ 4:30. ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿದೆ, ಬೆಳಗ್ಗೆನೆ ಹೇಳಿದೆ ನಾನು. ರಕ್ಷಿತಾ Which? ಇದರಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡಬೇಕು ಅಂತ ನಾನು. ಇದು JE electrical post. ಇದೆಯಾ post?
Same common notification.
ಇದೆಯಾ post? Assistant? ಎಷ್ಟು post backlog ಅಂತ ಮಾಡಿದ್ದಾರೆ? ಎಷ್ಟು post ಮಾಡಿದ್ದಾರೆ? Backlog ಅಂತ ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? Next ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಬ್ಯಾಕ್ಲಾಗ್ ಅಂತ tomorrow. What is this? What is list day after tomorrow? Master. Till number 2.
List number 2, my lord.
List 2.
Serial number 2, I am appealing for the respondent, my lord. Last occasion, they have actually directed the petition to implead the Union of India. They have not served the copy of IA, my lord.
All right.